This hearing is in the matter of case number CFI 024-2022 before Justice Sir Jeremy Cooke. The hearing is being held by way of video conference in the DIFC courts in Dubai. Any orders or directions made during or after the course of this hearing will be issued by the registry on the judge's instructions. The claimant is represented by White & Case LLP Dubai branch. Lead counsel is Mr. Tom Montagu Smith QC. The defendant is represented by Horizons & Co. law firm. Lead counsel is Mr. Sean Brannigan QC and Mr. Lawrence Page of Four Pump Court Chambers as his junior counsel. Thank you.
Yes. All right. Well, you're going to start, I take it, Mr. Montague Smith.
Oh, yes.
Yes. The point that troubles me most, I tell you at the outset, is the question of how one deals with the jurisdiction issue. Mr. Brannigan has made some submissions on it. On the face of it, my provisional view is this court clearly has jurisdiction, and that therefore creates a conflict of jurisdiction. And the wrinkle on that is that the decision of the onshore Dubai court was to dismiss the case on the merits, and as far as I know, there's no current appeal against that. But if there was to be an appeal, what do you say the position would be?
Well, I was going to take it in stages, my lord, but I'll get to the end of that question.
Yes.
But I think it does need to be taken in stages because there are case management issues about when and how you deal with this particular application.
Well,
if it is being made, because at the moment there's no application being made for a stay, and there has to be one. And instead of an application for a stay, what you have from the defendants is an inconsistent application to amend their defence. And your lordship's been faced with this sort of situation before, where a party accepts jurisdiction, then says, oh, actually, there isn't jurisdiction. And then halfway through an immediate judgment application says, oh, no, you've got to stay in favour of the JJC. And your lordship's view of that was pretty negative at the time.
I understand all of that, Mr. Montague Smith.
Yeah.
And assume I'm with you on all of that and not impressed with Mr. Brannigan's approach. The question nonetheless is there a conflict of jurisdiction where I'm bound to take it into account and notwithstanding all one's predilections to stay the matter? I think being absolutely frank and open with you both, having read the papers and looked at it, I think that is the real battleground for the day.
All right. Well, I think the answer is no. So the Court of Appeal's decision in Lacan says there has to be an application, and unless until there's an application, then there's no stay, and you can just carry on, right? But the other aspect of the decision in Lacan was to say the simple fact of two sets of competing proceedings does not give rise to a conflict, nor does an application to the JJC. What you need is an exercise of jurisdiction, a decision, a positive decision by both of the courts, or an exercise of jurisdiction by both of the courts.
Oh, okay.
Now, if there had been a jurisdiction complaint in this court, if there had been a proper application and a dispute of jurisdiction, which there is not in this court, there's simply an assertion, then you would have possibly said, let's deal with jurisdiction first, and then let's deal with the merits afterwards. And had you done it that way, you might well have reached a conclusion that you had jurisdiction, and then said, all right, so far as the DIFC court is concerned, there is now a conflict of jurisdiction, or at least there is what is required from the DIFC court's end for that. But unless and until you make a decision, unless until you do something, you make an order, your lordship, there is no conflict of jurisdiction between this court and the Dubai courts. And I can show you that in the legislation. I can show you that in the case law, if we get to it. But that's the broad position. So that's what Lacan changed. So when we were looking at this sort of issue in the context of the KVBO decision, and I've seen decisions of your lordship since then.
Yes.
In particular in the KPMG case, but when we were looking at this, and when Sir Richard Field was looking at it in the context of the hotel case, what was happening there was at that stage it was understood there was an automatic stay.
Yeah.
And that's an administrative stay. And my learned friend says in his skeleton argument that still remains the position after the Court of Appeal in Lacan. That's just simply wrong.
No, you can take it. I'm familiar with Lacan, but I would need to be taken to it because as matters stand, and obviously I haven't heard both parties on the subject, you know, I have a clear view as matters stand that this court has jurisdiction.
Yeah.
And indeed, Mr. Brannigan's clients have entered what we used to think of as an unconditional appearance, but acknowledgement of service without challenge.
Correct.
So that, so far as this court is concerned, on the face of it, there is jurisdiction. And the problem arises because the other court has held that it has jurisdiction. Now, are you saying to me that I don't have to make a decision about jurisdiction, so there is therefore no conflict because there's been no application for a stay?
Correct, and that the reason for that is that there are two ways there can be a conflict, and you'll see this in the decree. One is if there are conflicting decisions on jurisdiction.
Yeah.
And one is if there are conflicting judgments.
Yes.
And so logically, the mere fact that there is firstly a claim, and secondly that the courts consider that they have jurisdiction without making a decision, could not be sufficient. Otherwise, you would never get to the point of conflicting judgments.
Right. Well, I'm sorry to take you out of your course, Mr. Montague-Smith, but can we start there by looking at both the decree and Lacan?
Of course. All right. So there is a copy of Decree 19 that was put into the bundle last night. Your Lordship may have known from Lacan that there are multiple translations of it.
Yes.
But I was just going to work from Lacan in case there's any point that's made on it. But Lacan you'll find in bundle F. And it's at tab 7.
Yeah.
And the relevant passages at page 124. And you'll see the decree is recorded at paragraph 20 there.
Hold on. F. What page?
Page 124.
Thank you.
I'm afraid Gray's Inn have started mowing the lawn, so I hope that doesn't affect your ability to hear me.
I can't hear this.
Good. All right. So
not there yet. Oh. Taking me a long time, I'm afraid. Once you download it, you can't then do the find page thing. So you've got to scroll up and down.
You might be able to Control F if you downloaded it.
Control F. What does that do?
Might give you a search box, does it?
Oh yeah, very good. Very clever of you. Let me make a note.
I do have some.
You do have your uses, Mr. Bodge.
Occasionally.
Yes. Now I've forgotten the number. F127, did you say?
124.
124. Yes, very good. Yeah.
All right. So paragraph 20 recites Article 1 of the decree.
Yeah.
And if I can put it like this, broadly, it establishes that there are two forms of conflict of jurisdiction. So it says the competencies and powers of the JJC are determining the competent court to hear a claim or application in respect of which there may arise a conflict as to whether the Dubai courts or the DIFC courts have jurisdiction. So that's the first part, conflicting proceedings. And secondly, determining the judgment that should be enforced in a case of conflicting judgments issued by the Dubai courts and the DIFC courts in relation to the same parties. And you see that dichotomy again in Article 5, if you go down to the next page, in the middle of the page, which says what the effect of a reference to the JJC in the context of a disputed conflict of jurisdiction is the Article 5, the reference of any dispute to the Judicial Committee shall have the following consequential effects. 1, the claims or applications in respect to which there is a dispute as to jurisdiction shall be stayed, pending a decision of the Judicial Committee in determining the competent court. And 2, there shall be a stay of execution in respect of any conflicting judgments, pending a decision of the Judicial Committee to which judgment is to be enforced in accordance with its decision in the matter. So again, you've got that situation where, on one view, one outcome of an application of this sort in light of a conflict could be a stay of execution of competing judgments, and it's got to be implicit in that you could reach that point.
Yeah.
And the only logical way you could reach that point is if both courts either never look at the question of their own jurisdiction, which is the position in this court, or alternatively they do look at the question of jurisdiction, but they decide it together with the merits, which is what happened in the Dubai courts. And now this court sometimes, particularly in a case like this where it's very straightforward on the substance, this court sometimes does deal with jurisdiction and merits together. And you see that in particular in the claims to enforce foreign judgments. But sometimes it doesn't. Sometimes it breaks it into two. And so you might have a position where you have a decision on jurisdiction in this court, very often alone without the substantive decision. Very often in the local courts, they decide the two issues together. So there is a bit of a mismatch. But until you have those positive determinations, you don't have the conflict that is required. And that's essentially what the Court of Appeals said in Lacan. So if you go down to page 127, starting at paragraph 31, what triggers a stay then is the existence of a conflict of jurisdiction in one of the forms, the chapeau to Article 4, and an application to the JJC to determine the competent court or the judgment to be enforced. Mere application to the JJC does not trigger a stay, and the court must be satisfied that there is a conflict of jurisdiction. Sorry, I should have shown you what is the chapeau to Article 4, which is at page 125. And the chapeau to Article 4 says, in the event that there is a dispute as to jurisdiction between the Dubai courts and the DIFC courts, either where both courts have claimed or disclaimed jurisdiction, or where the two courts have issued inconsistent decisions on jurisdiction, the following procedure shall be followed.
Sorry, where are you reading from?
Sorry, that's the chapeau to Article 4 that's being referred to, and so that's page 125. I should have shown you that, paragraph 22.
Got it, yeah.
Yeah. I should have shown you that before I went to Article 3. So paragraph 31. So paragraph 31 then says, page 127, you need a conflict within the meaning of that. An application to the JJC is not sufficient. Paragraph 32, this makes good sense. There would otherwise be opportunity for abuse by making an application to the JJC asserting a spurious conflict of jurisdiction with a stay effective until the JJC determined that there was no basis for the exercise of its function, which, despite Article 3 of the decree, as the judge indicated, could be for a long period. And then 33, was there a conflict of jurisdiction in this case? In broad terms, and without at this point going to the different translations, the conflict of jurisdiction can be either through inconsistent judgments or through the courts maintaining or declining jurisdiction over a claim. This is not a case of inconsistent judgments, but the dichotomy is of some importance. Maintaining or declining jurisdiction over a claim must be something less than judgment on the substance of the claim. Conversely, mere existence of proceedings with the same claim in both of the courts cannot be enough for conflict of jurisdiction. As if that were so, there would be no point in making inconsistent judgments an occasion of conflict of jurisdiction. There would be conflict of jurisdiction before getting to judgment. So there, the Court of Appeal is making precisely the point that I was making. And then 34. that suggests an immediate difficulty for the claimant's submission. As noted, that submission rested on the Westlaw translation, taking up the words "no court decides to waive hearing of the action, or both courts waive the hearing thereof." The claimant said that it was not necessary that the court makes a decision on hearing the matter, and that it was enough that there was a negative act, meaning that it had not abandoned its jurisdiction. Thus, it submitted, so long as the two cases were alive without a ruling on jurisdiction, there was a conflict of jurisdiction. If that were correct, there would be a conflict of jurisdiction from the moment of commencement of proceedings, with the same subject matter in both courts, with no need or occasion for reference to inconsistent judgments. So that's what I say, where I say we are at the moment. And my learned friend says, well, it's enough that there is simply these two sets of proceedings. And I say, no, the Court of Appeal says that's not enough. You need a positive decision on jurisdiction. And that's why the Court of Appeal goes on at paragraph 35. The submission should not be accepted. When a party commences proceedings, it asks the court to exercise jurisdiction. The court does not do so by the administrative act of receiving the initiating process when filed. At the least, there must be some step in the proceedings amounting to a relevant exercise of jurisdiction by the court, or refusal of the step on jurisdictional grounds, in order that there be maintenance or declining of jurisdiction within the words of the chapeau of Article 4. All translations require a positive act on the court's part. Claimed or disclaimed jurisdiction, assert or decline jurisdiction over a claim. No court decides to waive hearing of the action, or both courts waive the hearing thereof. As to no court decides to waive the hearing of the action, which has had to be the nub of the claimant's submission as the negative act, it must be read with the alternative of waiving the hearing, indicating a choice. There must at least be an occasion for deciding to waive or not waive, as is clear from the other translations. So what we say here is that there are two problems for my learned friend in saying that there's a conflict of jurisdiction. First, the DIFC court has not taken a positive step. There's no jurisdiction challenge to adjudicate on. So the first positive step would be judgment, one way or the other, or on the application, either for immediate judgment or to amend the defence. And it's only after you decide those applications that there could be any exercise of jurisdiction. That's the first problem. And then the second problem, it arises out of what has happened in Dubai, which is that there are currently no parallel proceedings, because the Dubai court proceedings were dismissed. Now, my learned friend's clients have said, well, they intend to appeal, but there's no appeal on foot. And so the upshot of all of that is that there is obviously scope for there being inconsistent judgments. Albeit one might argue, if you dismiss my application, would that really be inconsistent with the dismissal of the claim in Dubai? Because it's not, you're not deciding the case against me. But there's a one can see how there might be inconsistent judgments. But actually, if you are with me on the immediate judgment application, there wouldn't even be inconsistent judgments at that stage either, because the judgments would be consistent.
Not unless there was a successful appeal in onshore Dubai.
Correct. There might be an issue which doesn't arise for you today. If I was successful today, and then there were two sets of appeals, one in DIFC and one in Dubai, but that doesn't arise for your decision today. And we can have an argument about that in due course as to whether or not the appeals need to be stayed.
Yes.
So that's the answer in my submission to the question of conflict of jurisdiction. Now, yeah. There is, though, and I don't want to repeat it, but there is, though, a question about whether or not, nevertheless, regardless of your views on that issue, you can still decide my application today. And I say you should do, and there's a series of reasons why I say you should do. Now I can set out those reasons for you now. I can set out those reasons for you later on if you want to hear from my learned friend on that, the first issue.
Well, I want to deal with this issue first, I think, because it's a precursor, so to speak, or a non-precursor, as you would say. But what you're were thinking of addressing me on was essentially discretionary reasons why I should go ahead, as opposed to matters that go directly to the issue of jurisdiction. Is that right?
Yes. What I was going to say was that at the moment there is no application to stay. You need an application to stay.
Yeah.
And so the question is, firstly,
well, I don't see how he can do that, having already accepted the jurisdiction by putting in an acknowledgement of service without challenge. I mean, on the face of it, he's stuck with it. I hear what Mr. Brannigan has to say on the point, but as matters stand, it appears to me he can't actually make such an application.
He can't make that application for those reasons to dispute jurisdiction.
Right.
It's too late for that.
Yes.
Could he nevertheless make an application for a stay, which is potentially a separate question?
On case management grounds or whatever.
Well, on JJC grounds, on the basis that there is a conflict of jurisdiction, regardless of the question of whether or not. So he might disagree with my analysis, and he might say, well, I don't have to show that there is an actual jurisdiction application. Should you nevertheless hear that application for a stay on JJC grounds? That's right. There is a question there. Now the case law says there needs to be an application. Part 23 applies, and so there are really, before you actually get, what I was saying was, before you actually get to the question of whether there's a disputed jurisdiction, there are actually three issues. The first is whether an application for a stay is being made. Now yes, my learned friend sets out a lot of reasons why he says, or he puts a lot of words in his skeleton arguments as to why there should be a stay. But there is no application for the court, and it's not just a technical point, because he does something opposite, which is he's actually, the live application which is listed, which he has made, is to amend the pleadings, to plead a positive defence. And not only that, along the way, he's made Part 18 or Part 19 requests for information and various other substantive things which would only make sense if he was going ahead with the action. So there is a question, is he actually making an application? And if so, what does he want the court to do with his application to amend? And it was in that context, in the hotel case, that Sir Richard Field said, well, look, you've got to put up or shut up, effectively. You can't make two inconsistent applications. But the second question is, the normal approach to an application is that you have to issue an application notice. So my learned friend would have to ask you to dispense with the need for that. And that's one of the points that Justice Wayne Martin made in the Emirates Hospitals case. So are you content to dispense with the need for an application notice and abridge time for an application, which would normally be 3 clear days, and deal with it on that basis? But say you're happy with those sorts of things, then there's simply a listing question, a case management question about when you hear that application. Do you list it for today in advance of the immediate judgment application? And in doing so, do you effectively allow this hearing to be hijacked by a new application, stay the proceedings, throw away all the costs associated with preparing for today for the applications that were actually listed? Or do you hear those applications first and then consider the issue of stay? And if you get to that stage, I just had a few short points about why you should push that application back, if I can say it like that. The first point is, obviously, we say that there is no, it's quite clear that this is a claim that was brought in the wrong court. There's no actual justification for bringing these proceedings in Dubai courts rather than the DIFC courts. It's a DIFC establishment. It's very clear. The second point is that not only is it indefensible, it's not actually defended, because as you say, there's no application to dispute jurisdiction, that there's a defence. There was a counterclaim. That seems to be abandoned. The third point is that the defendant intends to appeal in the Dubai court proceedings and has said that it's not going to, well, it says it can't get a stay of that proposed appeal. And so in correspondence, it said it's just going to carry on. It's going to march on in Dubai, effectively. And for obvious reasons, the claimant's concerned that these proceedings shouldn't stop now, when the Dubai court proceedings carry on. We should have, we say, that the protection of a decision on the merits. There are just a couple more points. One is delay. It's just this application hasn't been made up until now. These proceedings were served on the 25th of March. There was then a defence and counterclaim on the 11th of April. And then on the 4th of May, we get a letter saying, well, we've instructed counsel and we're going to amend. But it doesn't say stay. There's a request for information served at the same time. That's early May. The draft amended defence is served on the 19th of May. And it's only on the 20th of May, that's about 2 weeks ago, that a stay was first sought. So after all this preparation of the substantive claim, and then DIB applies to amend its defence a few days later on the 23rd, which, as I say, is completely inconsistent with the stay. So it's not just about delay, it's about blowing hot and cold. It's about taking inconsistent positions, making an application which it now says shouldn't be heard. That's why we do say that there are analogies with the KBBO situation, which was obviously completely unsatisfactory, where you have an application being torpedoed by a last-minute stay application. The difference is that we now know you don't have to. It's not an automatic stay, so you can decide not to throw all that cost and preparation away. And when it comes to it, as your lordship's no doubt seen, the substantive issues on the application are relatively narrow, and they're very straightforward. I mean, fundamentally, it comes down to the question of A, do we need and do they need and did they get consent for an assignment? And B, is it an assignment at all when it says it's a pledge? There are a couple of other points, but we can deal with those relatively straightforwardly. And then, if necessary, you can stay the proceedings after that. So that's the short point on all of that. Otherwise, what's going to happen? It's going to go off to the JJC. DIV is going to carry on pursuing its appeal in the Dubai courts, because we know the Dubai courts aren't actually staying anything in favour of the JJC. The JJC is a bit of a black hole at the moment. It took over a year for the KBBO case to come back. It may well, who knows how long it'll take. And we'll be back here before you in a year or whenever it is, arguing exactly the same issues that we can argue now. And we'll have wasted all that time and money. So those were my short points on why you should leave that over, even if you think there might be some sort of conflict.
Right. Let me hear from Flanagan on this. Sorry, I don't know why that should.
I'll mute myself just to make sure.
So good morning, my lord. My lord, I'm going to grasp this nettle by dealing with it in 5 short sections. First, I'm going to make just a few short but I think important points about the chronology that lies behind this. Secondly, I'm going to look back at Lacan and Lamia and back at the decree in order to make a point which I think might unlock the points that my learned friend has made. Thirdly, having looked at the law, I'll set out my submissions as to how the law applies to the facts of this case. Fourthly, I'll deal with the, if I may put it this way, the no application point. And fifthly, I'll deal with the position about the onshore proceedings, and in particular, the point which you made right at the start of the hearing about, well, isn't the wrinkle here the fact that at the moment, the case has been dismissed in the onshore proceedings subject to appeal. So I'm going to come to that as my 5th point. So points about the chronology. Here there are a couple of important points, including what has been said to the JJT or the JJC at the moment. And the points are this. This court is familiar with the tactic which some people adopt of whenever proceedings are issued in this court, parties running off to the Dubai courts in order to obtain or achieve a conflict situation. Precisely the opposite has happened in this case. In this case, whenever my client came to know about what had happened on the underlying facts in this case, it commenced its Dubai court proceedings on the 28th of January 2022. And importantly, didn't just, and it's important because of how jurisdiction has worked out in that court, didn't just issue proceedings against this particular claimant, the DIFCI, but rather against a number of parties that were all involved in that transaction. And the court will find that in the bundle at C194. So we started first, and we started in the Dubai court. And as it turns out, the Dubai court has agreed with us that jurisdictionally we were correct to do so. Now, for reasons we'll come to in a second, that does not mean that the DIFC is not also a competent court to deal with matters. But the Dubai courts have ruled that they are indeed a competent court, and there can be no doubt they've done that, not least because they have said that in their judgment, and they have then gone on to deal with the substantive merits. So we commenced proceedings in the Dubai courts, as it turns out, according to that court, completely correctly and appropriately, on the 28th of January 2022. The claimant opposed jurisdiction on the 16th of February 2022, and then waited some 5 weeks or so until the 25th of March 2022 to start these proceedings in this court. So the first point on the chronology is it is precisely the opposite of the usual situation you see, where a party has adopted a spoiling tactic in order to generate a jurisdictional dispute. We chose from the start the Dubai courts because, whether right or wrong, we felt that that was the best court for us and the court we were going to have a good chance of success in, and because of the different legal personalities involved in a claim against a variety of defendants. And so far, the Dubai court has not found for us in the merits, but has agreed with us in jurisdiction. And it is the claimant who has started these proceedings. It is also the claimant, importantly, that has referred this matter before we did to the JJT. And against the background of my learned friend saying that it is the defendant who is adopting contradictory and conflicting positions depending on the fora it is in front of, it is important to my respectful submission to look at what the defendant is saying, not just what it has said, but what it currently is saying to the JJT. And my lord, if you can pull out in your bundle, please, page C371, you will find the reference to the JJT. So, my lord, you have that. It's in bundle C, tab 26, beginning C371.
The Montague-Smith's method doesn't seem to work now. Never mind. All right, so it's all right, I'll get there. Right.
Thank you, my
sorry.
lord. So don't worry at all. We've all been through the case line system. It's a very good system, but when it doesn't work, it doesn't work spectacularly. Okay, so at C371, you will have the document the application that was filed by the claimant on the 5th of April of this year.
I don't have a C371, oddly.
Oh.
Mine stops at C370 and then starts at D1. Anyway.
That is therefore a problem. I think the issue is that the Judicial Tribunal application was added in yesterday evening. So if you downloaded the hard drive, if you downloaded it to a hard drive yesterday evening, it may not have been there when you downloaded it.
Right. Well, you tell me what it says anyway, and I'll find it later.
So, fine. So I'll quickly go through it. The key parts are this, from paragraphs 1 through to 13, which goes through to page C380. The claimant sets out the history of this matter. At paragraph 14, the claimant's position, as it currently stands, as it stood on the 5th of April and has not been amended since, the position to the JJT is as follows. In view of the above, a jurisdictional conflict exists between the Dubai courts and the DIFC courts, which is to be determined by the Judicial Tribunal established under Decree number 19 of 2016. So quite contrary to the submission my learned friend has just made, its position has been from the 5th of April that a jurisdictional conflict exists. Paragraph 17 of the document, paragraphs 15 and 16 of the document, the claimant recites some law to do with how the decree should operate, and then says at 17, the conditions are satisfied because A, a jurisdictional conflict arises in view of the concurrent proceedings before the Dubai courts and the DIFC courts, and B, the applicant has filed this petition to the Judicial Tribunal to resolve the jurisdictional conflict. At paragraph 26, which is C387, the current position which has been advanced before the JJT is that the DIFC courts have exclusive jurisdiction, and accordingly the Dubai courts must refrain from considering the claims. And then at page 388, the claimant asks for a variety of relief, but in particular, the second thing it asks for is it asks that the tribunal immediately order, pursuant to Article 5 of the decree, which you're familiar with, a stay of the Dubai court proceedings and the DIFC court proceedings until the Judicial Tribunal has issued its final decision on this petition. Now, in my skeleton, I wrongly characterised that as asking for a stay of the Dubai court proceedings. Sorry, the DIFC court proceedings. A more accurate way of putting it is they have specifically asked for a stay of both proceedings and have asked from the JJT for an immediate order to that effect. So
that's all good prejudice, Mr. Brannigan, but does it help on the issues of principle?
Well, it's not really intended to be prejudice. It's intended to indicate that, contrary to what you've been told today, the actual position that is being run by the claimant and which remains its position is that there is an extant conflict between the two courts.
I understand that, but if as a matter of law there isn't, within the meaning of the decree,
fine.
Then too bad that both parties have taken inconsistent stances and want to do different things at one time from another.
Of course, and I accept it. It's going to turn what the law actually says. So let's turn to that in section 2 of these short submissions.
Yeah.
So it's sensible to look back at Lacan against Lamia, because I agree with my learned friends that one of the benefits of Lacan is that it sets out the various translations. And I don't take issue with my learned friend pointing to the different translations. Yeah. And if we look back at where my learned friend looked at F124 and F125, the first and key point to make is this: whenever one looks at the actual decree, the decree does not work on the premise or on the sole premise that one or other court might be wrong as to its jurisdiction. So the decree does not work on the premise that for any particular dispute, one or other court, whether DIFC or Dubai Onshore, are going to be the only court of competent jurisdiction. The point that the decree is making in the specific context of the DIFC and Dubai is that whilst that might be the case, there may be an incorrect assertion of competency by a given court. It equally applies to a situation where both courts are correct, where both courts, Dubai and DIFC, both are entitled to exercise jurisdiction. And the point of the decree, in my respectful submission, is that it is an attempt to codify and or find a way of dealing with the conflict of law issues in the context of Dubai that arises from that. In other jurisdictions where it may well be that the Court of Belfast has got jurisdiction just as much as the Court of Hong Kong have over a particular dispute, you would exercise conflict of law principles to resolve it. But in this jurisdiction, the point of the decree is, as I say, to look at a situation where there may well be two competent courts and to work out how that is resolved in the context of Dubai. So that's the starting point of how the decree actually operates. And it means that my learned friend's submissions that if this court has jurisdiction, well, isn't that either the end of it or close to the end of it, is plainly wrong. If this court has jurisdiction, and we've dealt in our skeleton with this, and I don't shy away from the fact that this court on the face of it does have at least prima facie jurisdiction to deal with the DIFCI matter. That only raises the question of, well, what then happens about that? That brings us to Articles 4 and 5 of the decree, which are set out at paragraph 22 of the decision at F125. And the wording is, as my learned friend has already advertised, important. The wording of both Articles 4 and Article 5 are both important to deal with the issues which are before us today. Article 4 says, in the event there is a dispute as to jurisdiction between the Dubai courts and the DIFC courts, then it says this: either where both courts had claimed or disclaimed jurisdiction, or where the two courts have issued inconsistent decisions on jurisdiction, the following procedures shall be followed. And then it sets out 1, 2, 3, setting out an application to the Judicial Committee. Now, the reason that of course is exactly what has happened in this case. And that's the first point. As I've just shown you, there has been such a reference. The second point to arise is that, as my learned friend has indicated, Article 4 expressly envisages that there may be two separate situations where the decree applies. One is where there is inconsistent, where the courts have issued inconsistent decisions on jurisdiction. But the second is where both courts have either claimed or disclaimed jurisdiction. Now, there is no doubt, and I don't think my learned friend is seriously contending to the contrary, that the Dubai courts have claimed jurisdiction. This court has claimed jurisdiction. It has claimed jurisdiction because it has proceeded with this matter. It has listed this matter for hearing, including my learned friend's application, and it is clearly claimed jurisdiction to do so. Certainly, any precursor to issuing a decision in the merits must, by definition, involve this court claiming jurisdiction to do so. That is not least because one of the points of our defence, our draft defence, which we applied to substitute, makes exactly the point about a conflict of jurisdiction and asks for this matter to be stayed. So the suggestion that this court must actually issue an application on jurisdiction separately from taking the sort of steps it has done to consider this matter is inconsistent with the fact that the chapeau for Article 4 expressly envisages two separate things that can happen, both of which would then give rise to the need to get the JJT to resolve it. We come to Article 5 then, which says the reference of any dispute to the Judicial Committee shall have the following consequential effects. 1, the claims or applications in respect of which there is a dispute as to jurisdiction shall be stayed pending a decision of that committee. And 2, there shall be a stay of execution in respect of any conflicting judgments pending a decision of the Judicial Committee as to which judgment is to be enforced. Now, again, that is to be understood against the background of my first and primary point. The concept of a dispute as to jurisdiction, whenever you look at the decree and look at this wording, doesn't mean you need a dispute as to whether or not either court is wrong as to its jurisdiction. What you need is a dispute as to which court is going to trump the other, even if both are competent courts of jurisdiction. That's the first point. Secondly, the fact that Article 5 expressly differentiates between how you deal with claims or applications and how you deal with conflicting judgments, again, makes my learned friend's submission untenable. The submission to the effect of, well, what this court should simply go on to do is to issue a judgment, and then if need be, perhaps that might have to be stayed, we'll have to see. Article 5, by definition, is clear that it's not just judgments that you have to be aware of and to stay, but rather any claims or applications in respect of which there's a dispute as to jurisdiction. And as I say, a dispute as to jurisdiction doesn't mean a dispute as to whether or not, for instance, the DIFC has jurisdiction, but whether, if both the DIFC and Dubai Court have jurisdiction, what is to be done about that? And that's the JJT's function, and unusual function. So whenever one looks closely at the wording of Article 4 and Article 5, the scheme, for right or wrong, and my lord, both Mr. Montague-Smith and I have both been on different sides of this argument, with some people seeking stays and other people not seeking stays. For right or wrong, this scheme is really quite clear. That where you have two courts that are claiming jurisdiction, whether rightly or wrongly, and by the two courts I mean the DIFC and the Dubai Court, and there is a reference to the JJT, which in this case there has been, it is mandatory, regardless of what, with respect to the court, or indeed what Mr. Montague-Smith and I would on occasion think about this, it is mandatory that there is a stay, so that the JJT can consider which of the two courts is the correct one, both in terms of whether in fact they do have jurisdiction, and if they do, which of those two courts should take precedence in terms of how this is dealt with.
Your problem, Mr. Brannigan, is the terms of paragraphs 33, 34 and 35 of Lacan, which clearly envisaged that there could be two parallel sets of proceedings in both courts without a clear decision on jurisdiction in each court, with each saying, I have jurisdiction. Yeah. What your submission amounts to is that this court has to decide, regardless of any application that has not been made by you, in circumstances where you have accepted the court's jurisdiction, that because it is running proceedings, and proceedings have also existed in onshore Dubai, there should be a stay.
Well, I can understand why you put it like that, my lord, but in my respectful submission, that's not the right way to put it. I've got, I think, two submissions on this. The first is what 33 to 35 of Lacan is doing is differentiating between the simple fact that there may be ongoing proceedings on the one hand, and on the other, the fact that a court is claiming jurisdiction over something and exercising jurisdiction.
Yeah.
In this case, given the application which my learned friend has made, well, given the application my learned friend has made, by definition, he is asking the court to claim and exercise jurisdiction in order to give him a substantive judgment, and indeed the relief that he is seeking.
Would you do that in any set of proceedings, Mr. Bannigan? Whenever you go to a court and you ask the court to do something, you're asking it to exercise jurisdiction, aren't you? I mean, that's inevitable. That's the point that's made. In fact, at paragraph 34, the claimant's submission, it was not necessary the court make a decision on hearing the matter. The claimant's submission was it wasn't necessary for the court to make a decision. It was enough that it hadn't abandoned its jurisdiction. The two cases were alive, and therefore it could continue, because every time you go to the court, you obviously assert that it should exercise jurisdiction. I mean, it's inevitable, isn't it? And Mr. Montague Smith's point that you couldn't otherwise have two sets of proceedings means that that can't be a correct approach.
But
look at the first sentence, paragraph 35.
Well, that's exactly what I was going to bring you to. The differentiation here is what 35 is saying is that there is clearly a difference between a court simply reacting, i.e. A court accepting proceedings and undertaking an administrative act, versus the court not undertaking an administrative act but exercising a judicial function. That judicial function being asked to decide on exactly the sort of application which my learned friend has made, and also being asked to deal with the defence of the sort we have put in, which expressly flags up this issue and says in terms that there should be a stay. That's what the first couple of paragraphs of our defence expressly say, that given what has happened, there should be a stay, with the rest of the defence proceeding on the basis that the court disagrees. So that the essential split in Lacan is between an administrative function, which is receiving proceedings, sending out dealing administratively with the claim, and exercising a judicial function. And in a situation where the court is hearing argument now on this very point of, well, does the court have jurisdiction? And if it does that mean that Articles 4 and 5 are triggered? By definition, in reaching a decision on that, the court is exercising a judicial function and either claiming or disclaiming jurisdiction. It's impossible to deal with the subject matter, my lord, that we are talking about without the court either claiming or not claiming jurisdiction. And that's not an administrative matter. The registrar can't decide what we're asking you to decide this morning. Instead, what you're faced with is a situation where our defence is there should be a stay because of what's happened. You know that the claimant's position in the JJT is that there should be a stay because of what has happened, because there is a conflict in jurisdiction. We are here this morning saying our defence is there should be a stay before you consider anything else. That's exactly what our defence states. And it doesn't help my learned friend to say, well, he can't say that whilst at the same time saying this court has jurisdiction. Because my point is, but that's the point, that this court may well have jurisdiction, and the court I completely get the point that the court is currently minded to say it has jurisdiction, but that's nothing to the point. That simply means that two courts are claiming they have jurisdiction. And what my learned friend can't do is say that the exercise of this morning deciding whether you should proceed now to not grant a stay, instead to proceed to deal with the merits, and then deal with the merits. My learned friend cannot say that the court can do that without claiming jurisdiction. It is an essential function or part of the decision making for you to what you do about this stay, and then what you do about the substantive merits, that this court claims jurisdiction. Indeed, my learned friend says an essential part of his position must be that this court should claim jurisdiction to do so. So that, in my respectful submission, is the answer to the point. I'm not saying, as my learned friend suggests I am, that simply because there is ongoing proceedings in both courts, that in and of itself gives rise to the conflict. Instead, what I'm saying is that the Dubai court has exercised jurisdiction, and this court is claiming jurisdiction. And just to underline that point, can I direct your attention, my lord, to the last 4 lines of paragraph 35? It says, as to the no court decides to waive the hearing of the action, which had to be the nub of the claimant's submission as the negative act, it must be read with the alternative of waiving the hearing indicating a choice. There must be at least an occasion for deciding to waive or not waive, as is clear from the other transactions. Well, at a bare minimum, that is this occasion. Because the court cannot go on. I mean, the court could decide it was going to waive jurisdiction today. But instead, what my learned friend is inviting, what my lord has identified needs to be done is to take a view on jurisdiction one way or another. And not least because our defences expressly pleaded out in our replacement defence that there should be a stay. And in my respectful submission, this court cannot purport to go on and issue a judgment in this matter without first claiming jurisdiction. It must have it either has jurisdiction to do that act or it does not. And it must claim jurisdiction to do so. That is not an administrative act, it is a judicial act.
Why haven't you taken out an application for a stay?
Well, being absolutely frank, I understand the reason to be, because our application was for permission to rely on the defence that we put in front of you, and that defence, if you look at paragraph 1 of it, makes it clear that we are seeking a stay. And I think the view that was taken by those who instruct me is that our application to rely on that defence covered this exact point. Now, my lord may agree or disagree with me about that, but that's the view that was taken. Paragraph 1 of the defence says, if and insofar as the DIFC concludes it is prima facie jurisdiction to determine the claim, the matter should be stayed immediately, as a dispute will have arisen as to jurisdiction between the Dubai courts and the DIFC courts. And the second, that's the reality. This is the, and this is with respect is the opposite of the sort of situation where suddenly, by surprise, one party pops up at the hearing and says, we want to stay. It has been clear since we filed the defence, that was our position. It's been clear since we filed the skeleton argument. It could hardly be clearer, which is why my lord has identified that as one of the key, or perhaps the key issue to deal with today.
Well, what do you say about the point that you could never have 2 inconsistent judgments? If you're right.
Well, of course we could, my lord, is the short answer. And let's be. I think it's probably quite important, given that submission's been made to you, to note what exactly we have said about this. I'm afraid I have to bring you back to the bundle, my lord, and it's at section D, and it's tab 13, D 18 to 19.
18.
That's right, my lord. So tab 13, pages D 18 and 19.
30th of May letter.
That's it. Now, before I'm going to ask you to read that letter more, but there's a couple of important points here. Number one, of course, as you know, the claimant is party to these Dubai court proceedings. Point two, neither by return correspondence or my learned friend's skeleton has, or indeed in his oral submissions this morning, have they sought to gainsay anything said in this letter about how the procedure works in the Dubai courts. So what importantly, if you look, my lord, at the fourth paragraph down, the point which those who instruct me make in this letter is, at present, none of the parties have filed an appeal. This is in line with Article 159 of the procedural rules, under which all parties are granted 30 days to challenge the Court of First Instance judgment. As the FIC judgment was rendered on the 18th of May, the last day of filing the appeal by the party will be on the 17th of June. So the short point is, there is no, as I say, no dispute before you that everything we say in this letter is in fact is factually correct about the procedure in the alternative court, and we remain within time to file an appeal. We will be filing an appeal. Those are my express instructions, and that's what the letter says, written by Horizon Law Firm and officers of the court. And so there is plainly remains a real possibility of inconsistent judgments. The matter I would accept might be different if we had, I think I'd accept would be different had we exhausted the time for appeal or were out of time to appeal. Then one could see force to the submission that the proceedings in the lower court have come to an end. But the opposite is the case. We are granted 30 days to challenge the result. We are within that period, and we say we're going to do so. The position is therefore not in any way qualitatively different from a position where where the Dubai court had accepted jurisdiction, purported to exercise jurisdiction, but had not yet reached a judgment at first instance. We still have not had a final judgment. We are entitled to lodge an appeal, and that's what we're going to do. And that's why I say it's simply wrong to say that the proceedings in the lower court have come to an end. And that, in my respectful submission, is a direct answer to your lordship's question of, well, what do I say about the possibility of two inconsistent judgments? I mean,
you misunderstood my question.
Apologies.
The decree makes the point that inconsistent judgments can give rise to an application to the JJT. But if what you say is right, you could never get to a point of inconsistent judgments, because as soon as two courts, one in onshore Dubai and one in the DIFC, quote, exercise jurisdiction by hearing the claim on the same subject matter, you say there would be a stay, which would mean you'd never get to inconsistent judgments. That's the point. And what's the answer to it from your standpoint?
The answer to it is firstly Article 4.1 of the decree, which makes it clear that the mandatory stay provision doesn't just kick in relation to conflicting judgments, but sorry, I mean 5.1.
Yeah.
Rather than 4.1, that it doesn't just kick in for conflicting judgments, but also kicks in relation to claims and applications. So that, in my respectful submission, is the first answer.
Well,
the second,
it's not a sufficient answer, is it? Because it would render the need for judgments completely OTAs, inconsistent judgments, wouldn't it?
well, no. One can, I mean, there's a number of situations in which you could end up with conflicting judgments. I mean, one is that that either or both courts are not made aware of the existence of the proceedings in the other court until the judgments are rendered, which frankly has happened in the past, as I'm sure my lord is aware. So that's one possibility. The second possibility is that one or other court is made aware, but perhaps chooses to proceed nonetheless, which happens sometimes in the Dubai courts. And the third possibility, which is I mean, those are the first two obvious possibilities, that the courts simply are not aware of the relevant conflict until too late, and you end up with conflicting judgments. I've given you a second possibility. The third possibility, which I would accept is probably going to happen less often, but is still a real possibility, is that for whatever reason, the conflict, the overlapping of the subject matter or the conflict between the two courts does not become aware until the two judgments are released. I mean, let's imagine a situation where a Dubai court is asked to deal with disputes between parties, and it is not apparent to anyone that the Dubai court's decision is going to be sufficiently wide-ranging as to cover some subject matter which is also being dealt with the DIFC court. But then,
hard to imagine that, Mr. Brannigan.
Well,
assuming
in Dubai courts, I find it very hard to imagine that it would happen from a judgment being released in the DIFC court, that the parties would not anticipate or realize that judgment was going to deal with subject matters being dealt with in another court. That I would entirely accept would be a very surprising result from a DIFC court's decision. Putting it gently, I do not accept that the same sort of or extent of surprise would emerge if you had a ruling from a Dubai court, particularly if an examiner had gone in, an examiner of the sort, my lord, that you'll be familiar with operating in the Dubai courts, had gone in and had a look at the subject matter, and then a decision is released. As I've accepted, that seems to me to be less likely than my first two situations, where judgments are released simply because the courts didn't appreciate there was such an overlap and perhaps they weren't told by the parties. But I do, I'm afraid, maintain my submission that it is possible that you could also have a decision from one or other court, and in this sense I say it's more possible from a Dubai court, which takes the parties by surprise in terms of the subject matter that it deals with, particularly where there's examiners involved. Now, neither me nor my learned friend can give evidence, but I would simply ask the court to accept that certainly in decisions emerging from the Dubai courts, that is not an impossible situation to envisage. But the reality is that there has to be a reason why Article 5 differentiates between 1 and 2. Article 5 is express that you don't need to be a conflicting judgment. A claim or application is good enough as long as as part of that claim or application there is a dispute as to jurisdiction, and Lacan tells us that means a claim of jurisdiction by at least two competent jurisdictions. And as I say, the other reason I say that you might well get it is because either because the parties have not applied to the JJT, or they've not applied in time, or the court has not been made aware of it it actually gets through the process and you end up with conflicting judgments. And that, I would respectfully submit, is clearly a real possibility, particularly in a situation where parties may be represented by variable degrees of representation, and with some representation not immediately being familiar with DIFC procedures and or with the need, if the DIFC procedure is kicked off, what it's going to do about that. Again, whilst I can't give evidence, it may be the court has sufficient experience of realizing that there are a number of ways in which a party could end up not making its application in time in this jurisdiction to the JJT, or one or other court not being told about the other set of proceedings. And that is, in my respectful submission, why 5.1 and 5.2 differentiate. And I would put it back the other way on the court, if I may, my lord. There clearly must be a need for 5.1 for some reason. And that reason is clearly that the decree recognises that you should, if you can, deal with this before you get to the judgment stage. That's the whole point of 5.1. And not just, sorry, forgive me, it's not just should if you can, but the words shall be in 5.1 mean that one must, if one can, deal with it before you get to the judgment stage. With 5.2 dealing with those situations where that has not happened. So, my lord, those were those were, I think, the 5 different headings I was going to make my submissions under. Standing back and looking at it, just to pull the threads together. As I say, I suspect all of us in the court have scratched our heads now and again about both how the decree operates and indeed the wisdom of it. But there it is, and it's mandatory. This is the opposite of a situation where we have gone second and tried to scupper matters. We just want the onshore courts to deal with this, and we issued first. The other side, their position is that there should be a stay of all of this. And our simple point is...
That's not their position today.
No, it is. It is. It's their position today, as with the JJT. They haven't amended that position. It's just that their position in front of you is different than their position in the JJT. But ultimately, it comes down to my learned friends seeking to get round the decree in a situation where if you don't stay this and you issue a judgment, that is exactly the position with the ongoing proceedings in the Dubai court still ongoing. That is exactly the position that the decree is intended to avoid in order to preserve comity between the two jurisdictions. So, those are my submissions.
Right.
If I may, my lord, I've got some very brief observations which I would be of some assistance. First, my learned friend said repeatedly that this could be a case where both courts have jurisdiction. That is simply not logically possible on the legislation, as your lordship will know. Article 5 of the Judicial Authority Law confers jurisdiction on the court, on this court, and it does so in relation to Article 5.1a exclusively. And if you need to look at it again, that's at page F3. So where the court is dealing with a DIFC establishment, this court has exclusive jurisdiction. That is, and there are, I mean, we can dig out the authorities if you want. There are endless authorities which show that the result of that sort of jurisdiction is that no other court has jurisdiction. There's a question about how far that goes. Is the legislation saying no international court has jurisdiction? Probably not, but it is certainly saying the Dubai courts don't have jurisdiction.
Well, I understand that, but how does that really help, Mr. Montague Smith? I may be absolutely persuaded of that. In fact, I am, but I'm not sure.
I think it's simply it was a refrain that ran through all of my learned friends' submissions. So I simply wanted to clarify that. Insofar as there is a discretion, and there is, I say, as to when you deal with this application, it could be relevant to that. The reality is, as I've said, and it goes to my submissions on that, that there is no defensible position for starting these proceedings in Dubai. There's no excuse for it. There's been proceedings between these two entities in the past. They're advised by DIFC regulated lawyers. Anyway, I'll leave it there. The second point is this, and I think in a way that there's not a huge difference between us on the principle. I think what my learned friend was saying was that part of the reasoning in Lacan is that one has to distinguish between the exercise of an administrative act by the court and judicial function. The bit that he misses is that the conflict of jurisdiction only arises after the relevant act has been undertaken. So it's not the occasion for the exercise of a judicial function that triggers a dispute of jurisdiction. It's actually the exercise of that judicial function, issuing a judgment, making a decision. That's what Lacan is saying at paragraph 35 in that passage that I took you to, and that is also clearly the consequence of Article 4 of the decree, which we can see again in Lacan at page 125 of the bundle. So it's Article 4, the chapeau of Article 4.
Yeah.
In the event that there's a dispute between the Dubai courts and the DIFC courts, where either both courts had claimed or declaimed jurisdiction, so it's in the past. It's the claiming or the disclaiming of jurisdiction, the judicial act in doing that. Now, clearly, if you are to give me immediate judgment, then that would be an exercise of jurisdiction. But until you do that, it hasn't happened. The chapeau is not satisfied, and there's no conflict. That's what Lacan is saying. That's what it says at paragraph 33 and 35. It's saying until there has been a judicial act. So unless you are saying that simply listing the hearing is sufficient, then the problem with my learned friend's argument is that it always runs into paragraph 35 of this judgment, because it always reduces the requirement to something which arises in every single case. You will always get to that position. You'll never have a hearing, because simply listing any hearing would be sufficient. But that's the administrative act, and it makes sense in this regard. First, the point that there is provision for conflict of judgments. My learned friend's examples require you to consider that the decree is legislating for those sorts of situations where there's some sort of unexpected decision in one court or another. And again, it runs up against Lacan, where it's saying there would be no point in having those provisions if the other party was right. If the answer to that question is, oh, well, there might be inconsistent proceedings that one or other court wasn't aware of, if that was the answer now, then it would be the answer in Lacan as well. But it's not the answer. We can see that from Lacan. And so there's this suggestion that, because the other suggestion was that this is explained because the consequences of a conflict of jurisdiction require a stay of the action. But that doesn't answer the point, because you can have a standalone jurisdiction decision in this court, and then of course the action will be stayed.
Sorry, say that again.
So part of the answer that was given was that you need that the effect of Article 5 shows you that I am wrong. Why? Because Article 5 says that the stay bites on the claim and applications in the claim. And so if I was right, the argument goes, then that wouldn't work, because I say you have to decide the claim before you get to the dispute. But that doesn't answer it, because in this court, very often, jurisdiction is decided first. And actually, that is the positions quite often these days in the Dubai courts too. It happens sometimes one way and sometimes the other way. So that just doesn't answer the point. And then and there's also no real answer to my point that there are no proceedings on foot in the courts in Dubai as we sit here today. And that's a material point, because if I'm right, the effect of that is that it avoids one of the courts effectively stealing a march on the other court. It gets to, if one court gets to judgment, then the other court has to get to judgment before there's a conflict. You don't lead to this race between the courts to get into judgment. It's only once you get there that then you have a conflict of judgments. And that also brings you back to the question of why you need conflicting judgments. You need that informs the question that you have to decide with whether or not there are competing claims still in the two different courts. Because if the existence of a judgment in Dubai and proceedings in the DIFC was sufficient to amount to a conflict of jurisdiction, then you would never need the conflict of judgments provision at all, because you would always be in a situation where both courts got to the end of it. If both courts had reached the end, at the point where there were two conflicting judgments on the substance, on my learned friend's approach, that has to count as conflict of cases, conflict of claims. So that also shows you that he can't be right about there currently now sitting here today being two conflicting sets of proceedings. One's finished and one hasn't. On the issue of the application, why hasn't there been an application? Well, my learned friends, I mean, it's slightly, well, you tell me. I mean, what he says is that they pleaded it out. They pleaded out their right to a stay in their defence. The actual factual position is the defence as it currently stands does not. What they've done is they've put it into their draft defence. So firstly, an application for a stay isn't a defence, but put that as to one side for the moment. My learned friend says, well, okay, you can take it that they're asking you for a stay through the mechanism of their draft amended defence. So to get there, he has to say you have to amend the defence first. So what is he saying? He's saying you ought to hear his application to amend his defence, to introduce, amongst other things, this passage which says you've got to stay the proceedings. Then pause there and decide that discrete aspect of his defence, stay, and then stop. So you've got to actually hear his application for an amendment in part to get to his application for a stay. But as to the fundamental question, the answer is Lacan. The answer is the Court of Appeal has decided this. Whatever you would give as a free interpretation, and Lacan was a change, because as you know, my lord, before Lacan, everybody thought that there was an automatic stay.
Yeah.
On the face of that legislation, that's one arguable way to interpret it. But Lacan says that is not correct, and you have to give effect to that. And the only way you can give effect to that properly is to see it as requiring a decision which is either on jurisdiction or which is an exercise of jurisdiction. Until you get to that point, you don't have a conflict. And that ultimately is how the Dubai courts are operating as well. So in my submission, it's right that these courts should have one eye on the practicalities of that, because the effect otherwise, and it does happen, is that the DIFC court very properly says, right, we've got no option but to stop now, and the Dubai courts just keep running. This is some part of an inroad into that. It doesn't avoid the situation where you have an actual jurisdiction dispute in this court, which is decided discreetly, but not in the Dubai courts. But it does avoid the situation, which is what my learned friend is trying to generate, which is where one party can carry on with its action in its chosen forum, plainly the wrong forum, and block corollary proceedings in this court. Well, unless you wanted to, if there's anything else I can add on that, those are my submissions in response.
My lord, I haven't got. Sorry, I haven't got a right.
Try again.
I haven't got a right of reply, but there is one factual matter which is important, because it's to do with the translations. My learned friend in his submissions just now placed some emphasis in the use of the past tense in one translation of Article 4, which is the translation which is set out at paragraph 22 of Lacan, which talks about a dispute as to jurisdiction between the Dubai courts and the DIFC courts. Either or both courts had claimed or disclaimed jurisdiction, and my learned friend put emphasis on the past tense of that. I won't make submit. I'll simply say that if you read the two alternative translations, one of which is set out in paragraph 26 of Lacan, and one of which is set out in paragraph 27, neither of them use that past tense. They both use 26 uses the present tense. In 27, whilst I'm a grammar school educated boy, I'm not quite sure what the name is of the tense that is actually being used at 27, but it's not the past tense. If anything, it's the present, but I'm sure it's a particular grammar derivation of the present. It says so that no court decides to waive hearing of the action.
Yeah, all of that. Thank you for those replies.
I'm just pointing out.
Hold on, let me just.
I'm not sure. I'm not entirely sure it's right that Bernard Frank comes back yet another reply. I'm simply pointing out that whilst he's relying on the past tense of that, what in fact the other two translations say.
Yes, but all of that has been dealt with in Lacan at paragraph 35, where it looks at precisely that submission and rejects it. That was the point that I was going to make. F127, paragraph 35. It makes precisely that point and rejects it. So I'm not quite sure what my own friend's point is there.
Well, I don't think it does, but again, I don't want to go ping pong backwards and forwards. But what my submission in response to that is paragraph 35 doesn't do that at all. So my learned friend was making point about past and present tense, and that's not what 35 is saying.
Yes, it does.
Okay, very good. Right. Well, I've had all your submissions on that. We'll proceed with the rest of the hearing, and I will cover the ground in the reasons I give at the end of the day. So whether we consider this to be Day Bain ASA or anything else, we carry on.
Thank you, my lord. All right, I was going to go first. Again, it's my application for immediate judgment.
Yeah, I think so. Yes. Hang on a second. Wait a minute. I just want to reorganize my notes.
Of course.
Thank you. That's fine. Yes. On to the substance then.
Thank you. All right. Well, your lordship has heard a little bit about the background, but and will have read in to the case, no doubt. I was going to just remind you very briefly of the chronology, identify what I say are the issues, and then take them one by one, if that's acceptable. Starting with the chronology very briefly, the first stage happens in March 2016. The bank provides a facility to the contractor. That's BIC. Your lordship may have seen that contractor had various other names along the way. So Al Habtor Leighton was one, HLG is another, but I'm going to call them BIC or contractor. So that's March 2016. The next thing that happens is that in October, on the 26th of October 2016, the claimant and BIC enter into a construction contract. Your lordship may not have been to Dubai very much recently, but this is a construction contract that related to the Gate Avenue in the DIFC, which is the section of the DIFC that runs between, on the one hand, the Ritz-Carlton, and on the other hand, Currency House and now the ICD Brookfield development, and it goes all the way up to the tip of Park Towers. The only thing I need to show you in the construction contract is the no assignment clause. I'll just show you that very briefly so you've got it in mind. It's at page 48, bundle C, tab 3.
Now getting all the C48 references in your skeleton.
Oh,
Never mind. Okay. Oh,
I won't ask you to search for the word assignment, which is the other one that occurs.
easier fact.
I don't know if you've got the tabs. They do open out.
I don't seem to have the. Oh, well, hold on. Actually, I'll go back to the index.
Well, if you've got a full, I don't know whether you're working from a single PDF of the entire bundle.
I am, yeah.
If you are, I'm told it's on page 116 of that PDF.
Thank you. There are a whole lot of blank pages in here for reasons that I can't quite follow.
There shouldn't be. So maybe there's a problem with what's been downloaded.
Yeah, that's the problem I was having. Yeah, including page 116, which is blank.
Ah.
What a pain. But you've cited it, haven't you, in your skeleton?
Yes. Let me
Unless
try
someone's
work
going
from
to
the
say.
skeleton. So we've got it at page 11. Let's do it that way. Paragraph 48.
Yes.
So
yes. Unless there's some, Mr. Brannigan will tell me if there's any issue about the wording.
There is not.
Thank you.
So this is provision in the construction contract that between DIFC and BIC, and 3.1a of that says the contractor shall not, without the prior consent of the client, sign, transfer, or novate. So it's requirement, firstly, for consent, and secondly, that the consent come before the assignment. Those are two important points. Just sticking with the chronology then, there is then on the 29th of December 2016, so a couple of months later, what the bank has called an assignment. We are going to have to look at this at some point.
Yes.
I don't know whether I've recited it in terms, I don't think I have, because it's rather lengthy, but it appears at page C127.
Let's see if we
I mean, I'll come back to that document in due course, but just so you know what I say about it. The DIFCI saw this document first when it was attached to a defence that was produced in these proceedings. And what we say about it, is that it is not purporting to effect an assignment, that is a transfer of title to the receivables under the construction contract, it is a form of security. It calls itself a pledge. That's paragraph 1. And it calls itself a form of security throughout the document. And importantly, what I'd ask you to note, I don't know if you have it in front of you.
I do.
So at 4A on page 120, sorry, 4E on page 128, one of the things that the contractor was required to do was promptly pursue any remedies available to us, that's the contractor, in respect of any breach, in respect of any claim in relation to the receivables, in accordance with the relevant provisions of the project's contract and documents. So we say that it's very clearly keeping title to the receivables with the contractor. One of our friends says differently. Now, around the same time, notice is then sent to the DIFC, and we see the notice on page 129. And it's a related but separate point arises out of this, because what is said here is that there is an assignment by way of security. So we say that what is notified to the DIFCI, regardless of what actually happened, what was notified was not a true assignment, but a form of security. And I'll come on to that in a moment. And then, importantly, the contractor asks DIFCI for its consent to an assignment or to this arrangement, and we see that at 134. What is sought, and what is sought is in terms consent. So the draft that is provided by the contractor to DIFCI starts in the first paragraph. We refer to the irrevocable notice that we received from HLG Contracting, that's BIC, dated 29 December 2016, and consent to the assignment. So BIC presents this to the DIFCI for signature. But in fact, DIFCI doesn't sign that document. They sign a different form of language. And we see that language at page 137. And this comes back in January 2017. So you'll see it referred to as the January 2017 notice, the January 17 confirmation or acknowledgement, whatever you want to call it. I'll call it the acknowledgement. And you will see from that it refers in the first paragraph to an assignment that you have purportedly entered into. So that's the last two lines of that first paragraph. So it's not accepting even that the assignment has occurred, and notes, by the way, in the last paragraph that the DIFCI hasn't seen it. And then there'll be a bit of argument about what's meant by the second paragraph, what the effect is of the second paragraph.
Can I just be clear about this?
Yes.
My understanding is, and tell me if I'm wrong, that this is addressed to the bank, but in fact gets sent to BIC. Is that right?
I think that is right, yes. But it is addressed to the bank. And so it's
does the bank, is it common ground or is it not common ground that the bank saw this?
For the, I don't know if there is any particular evidence about that.
No, I don't think.
I don't take a point on it. If you're thinking forwards to questions of waiver and estoppel and all the rest of it, I don't take a point about whether or not the bank saw it,
right. Okay.
or indeed that anything turns on the effect of the actual assignment in law as a result of whether the bank saw it or not. I don't take a point for the purposes of today.
No, thank you.
All right, but the really important part of this, one of the important parts is the second paragraph. Then, so what the what DIFCI was asked to do was promise to make payments into a particular bank account and not to change that unless the bank told them otherwise. What they then do in 137 instead is they make all of that subject to instruction from BIC, from HLG. So they say, until we receive contrary instruction from HLG, the contractor, we confirm and undertake that we shall pay the sum into that particular bank account or such other account as you may at any time notify to us in writing. So I'll come on to the submissions in relation to this, but as to the question of whether or not this is some sort of promise to make payments to the bank, to make payments always, regardless of what the contractor says to them, we say that's obviously not what's going on here. What's going on here is that we are saying until the contractor tells us otherwise, we will make these payments to that bank account or wherever you want it. It's all subject to the contractor's instructions, and so we say this doesn't give consent, and secondly, it comes after the assignment, so it's not prior consent. Next, what happens is the construction contract proceeds and payments are mostly paid into the designated account. There was an advance payment that went into a different account, but about 430 million dirham is then paid into the designated account. So with the advance, the total amount paid by the DIFCI under this construction contract is in the order of about 480 million, 480 million. So pretty close to the contract sum. But there's then an arbitration between the two parties. That's the contractor and the DIFC investments, because there's an arbitration agreement in the contract. Now, one of the things that the bank has revealed recently is that it was fully aware of the existence of that arbitration. It says it didn't know the details, but it clearly was aware that a claim was being advanced by BIC against DIB in those proceedings under the terms of the contract. We know that from emails that the bank has produced very recently, just a few days ago. And there are two email chains which are included at the end of the bundle. I just want to show you three of those emails, if I may. They are probably at the end, right at the end of your bundle. If it hasn't been updated, there's one or two documents that have been added. It's page 334 or C334. Actually, it won't be the end of your bundle if it's a full PDF of the entire case, but C334. And so at the bottom of that page, 334, you see an email from the bank to BIC, and this is in, it looks like April 2021. Dear Dr. Khalid, awaiting update on the below points. Point number one is kindly advise on the latest update of the legal proceedings on DIFC and FICI hospital projects. And then on the previous page, 333, you get the response from BIC. Status of the arbitration. So, dear Mr. Wasim, but under the heading number one, status on arbitration, DIFC arbitration is well underway, where our claim against the client is for 292 million dirham, including bonds. We've been preparing our statement of defence, which we'll be submitting shortly. So it's a statement of defence because there were two, the DIFCI was the claimant, and so there was a counterclaim. And so what BIC is telling the bank here is that it is advancing claims against DIFC under the construction contract. If you go back to the page above, page 332, you can see the email at the bottom of the page from the bank, this time to BIC. Dear Dr. Khalid, thanks for your below response. Request you to provide some information on present status of litigation fund raising with LCM. That's the fund. That's the funder. And then this part. Background noise. It's not coming from my end. I think it's Mr. Adel Ahmed Al Jazmi. If he could just mute, please, that would be helpful. Thank you. Oh dear. All right. Anyway, so just the response comes back from the bank, and it says our previous restructuring approval.
Sorry, which page are we on now?
We're on 332.
Yep.
Our previous restructuring approval presently stands cancelled. Was entirely dependent on completion of due diligence and commitment from LCM to fund litigation expenses for DIB projects, namely DIFC and Faki Hospital. So just pausing there to think about this for a moment. DIB's case today is that the rights under the construction contract were assigned legally to it. So it had title to those receivables, and BIC did not. Otherwise, its claim against DIFCI just doesn't work. That's the whole premise. And yet here, the bank is positively insisting on BIC pursuing those claims. The restructuring was dependent on it obtaining funding to do so. So at the least, one can say from these exchanges, it is very clear that DIB itself did not think that there had been a true transfer of title. Now, if that wasn't correct, DIB would here be requiring BIC to pursue a false claim. So we say, at best, this must simply dispense with any Estoppel arguments that DIB has, because Estoppel would have to proceed and waiver would have to proceed on the basis that, in light of statements made, the bank thought that it had title. But we can see here it clearly didn't think that. But we say it does also shed light on what this so-called assignment was really intended to achieve. And and I'll show you, I'll come back to these submissions in a moment, but we say it was obviously intended to achieve some sort of security arrangement. These email exchanges, we don't need to go there, also show that that settlement was always in contemplation, and that's what happened. So DIFCI settled with BIC in November 2021, and I'll just show you that very briefly. It's page C141. And at page 143, you see the settlement amount is for 20 million dirham. And at page 144, you see the releases at paragraph clause 4, which release both the claims and the counterclaims. And then that sum is paid. And so as far as DIFCI is concerned, that's the end of it. It's reached a settlement with its contractor, it's paid out what was due, it's settled off all its own claims and the contractor's counterclaims. And the evidence from Mr. Visser is that subsequently the contractor demobilized and is replaced by other contractors who complete the works. And then on the 28th of January, DIB starts proceedings in the Dubai courts. And I don't think we need to look at them in too much detail, but if you look at page C194, you can see broadly what's being claimed. We need to go to 195. And you can see there are 4 defendants, and DIFC Investments is the 4th defendant. And against all of them, the claim is made for 191 million dirhams plus 20 million late payment damages, so a little over 200 million in the end. So that's the end of January, and then these proceedings are commenced in March, and the application for immediate judgment was issued at the same time. So what are the issues before you today on the applications? It's my application for immediate judgment, it's my learned friend's application to amend. The test is the same on both. Real prospect of success. Strictly, I have the burden on my application. My learned friend has the burden on his application, but there's an overlap of issues. And he wants to replace the whole of the defence, but retain some of the points that are made in the defence. It probably won't make much difference about where the burden lies. If I can ask you just to look at the skeleton and go to page 9, you'll see the issues as we set them out. And some of these don't appear in my learned friend's skeleton argument. And I don't know what's happened to them, whether they're dropped, whether they'll be orally articulated, I just don't know. So the first issue that arose is whether or not clause 3.1, which I showed you, what is the effect of that as a matter of law? Is its effect that without prior consent, the assignment does not have effect to transfer a receivable? So assume that it's an assignment. Does clause 3.1 operate to prohibit an assignment without consent? So DIB, I think, says that no consent is required. At least that's their pleaded case, and also their pleaded case in the amended defence. It doesn't emerge from their skeleton argument as far as I can tell. But they certainly pleaded that no consent was required. That was said to be as a matter of construction, firstly, if you look at our clause 3.1 A, or alternatively, as I understand their argument, they say because assignments cannot be prevented by contractual clauses. So in other words, they say that clause 3.1A, whatever its effect, whatever it means, does not prevent assignment. They argue that in their pleading in a number of different ways. First of all, they say UAE law applies to that issue, but they also say the same position arises if DIFC law applies. As I say, I don't see that in the skeleton argument. I don't know whether the point's been abandoned. Overnight, there's no reference, for example, to the UA law position whatsoever in my learned friend's skeleton. But overnight, we've received a couple of authorities which appear to indicate that this is a live issue. What will be said about those authorities, I don't know. The authorities are UA law authorities. I will show you them, and we will see that, at least I say, those cases don't support DIB's position. The second issue then, so that's the first issue, is could that clause be effective to prevent a transfer of rights? The second issue is if so, was consent given? And as I read it, that's the only issue on assignment which is actually argued in the skeleton argument. Save for this, there's also this bare assertion that the DIFCI was a surety, and I'll deal with that separately, but as to assignment, that's the only point that's taken in the skeleton. So, and it's also narrowed in the skeleton argument, this point, because in the defence, it was said that consent was given in two different ways. And you'll see that at subparagraph 2b in our skeleton on page 10. It was said that, firstly, DIFCI consented by making those payments into the designated bank account with DIB. I think sometimes my own friend Skeleton says that the payments were made to DIB. To be clear, they were paid to a BIC bank account held with DIB. That may or may not be important later. So that was the first way it was said, but now the only way, the only point raised is that acknowledgement letter from January 2017 should be interpreted as consent. And we can look at that document again. We've looked at it already, but I think you can decide that point pretty quickly. We also say that it had to be prior consent, and that's a meaningful requirement. And if we're right about that, then the whole consent argument really falls away, because nobody says that anything amounting to consent took place before the assignment. So there is no case that there was prior consent. There's just a case that there was subsequent consent. And I'll show you an authority from England which says that that is a meaningful requirement and that's the end of it. But again, we don't have any submissions on this from the bank at all. They just ignore the point. So that's the second issue, whether there was consent.
But if there had been a consent ex post facto, that would also amount to a waiver of the need for prior consent, wouldn't it?
Well, it might do, but only if it was relied on as effectively resulting in a transfer. And that's the point, that the estoppel and waiver arguments just don't work, because we see from the correspondence that they knew, well, they took the position that there wasn't a transfer of rights. So yeah. I'll deal. That's the next point, though. That's the third issue, which is the waiver and estoppel argument. And again, I mean, that doesn't feature in the skeleton argument. It's pleaded out in the defence, but we don't have it in the skeleton argument. But it has, we say, all of the problems of the consent argument. You'd have to look at the argument that there was consent. So it doesn't actually take it any further, really. But it also suffers. Say deals. Would, you're right. If it was made out, might deal with the prior consent point. But it also suffers from the problem that the correspondence shows that the bank expected the contractor to make the claim itself. So that's the third point. And then the fourth point is, what is the true nature of this so-called assignment? Was it actually an assignment in the sense of transferring title? We say it wasn't. We say it was a security arrangement. It's what the DIFC and UA law call a pledge. But we raise that squarely in our application, and again, there's just no response to it in my learned friends submissions. And if it's not a true assignment, again, the case doesn't work. And then the fifth point is related, which is, whatever it really was, what was the DIFC given notice of? Was it given notice of a true assignment or a security arrangement? And it was told, as you've seen, that there was an assignment by way of security. We say that has a particular meaning, and DIB ignores it. And then the final point, well, not quite the final, the sixth point, which is raised in the skeleton, is that the bank asserts that the DIFC was in a position of surety. That is, that they were the guarantor of the loans. That's asserted but not argued. We say it's a pretty odd proposition. But and then finally, although it's put first in my learned friend skeleton, the bank asserts that there may be counterclaims in future. And the short answer to that is that there aren't any now. And certain counterclaims, potential counterclaims, are postulated, but in fact, when you look at them, there's no basis for asserting them whatsoever. Somewhat unfortunately, the bank uses words like fraud and dissipation in its skeleton argument, and there's various sort of suggestions that the payments that were made in settlement were unusual. All of that, we say, is to try to muddy the waters and insinuate a claim, potentially a serious claim, which is never articulated and which wouldn't have any substance if it was. So I'm going to, with your permission, deal with the issues in that order, if I may, and start with the question of the consent requirement. As I say, it's not obviously tackled in my learned friend skeleton argument. As we understand it, there are, as I say, 2 points made, one about construction, and the other is that whatever was agreed, lack of consent, can't stop an assignment. Now, this starts in my learned friend's pleading, and I'll show you this, with an assertion that UA law applies to this issue. You'll find it in the draft defence, page 25 of the bundle. And it's clause 11 or paragraph 11.1. So what is said is that 11, whilst BIC sought the claimant's consent to assign the receivables, the assignment took effect and became binding on the claimant regardless of whether it consented. And then looks at two possibilities. One is if UA law applies and one is if DIFC law applies. So 11.1, if, as the defendant contends, UA law applies, then prior to that particular decree, the assignment of contractual rights was governed by case law, and B, the UA courts have consistently ruled that consent or acknowledgement is not required for an assignment to become effective and binding on an obligor. an obligor is only able to pay the original creditor if it has not been served with a notice of assignment. Now, so starting with the UA position, and we say that actually that plea doesn't answer the question. That just sets out the general proposition that generally consent is not required. And that's usually the position whether you're dealing with DIFC law or English law or whatever system of law. Unless there's some contractual restriction, then consent is not required. The question which needs to be answered at this stage is whether, if the contract requires consent, can the party entitled to payment nevertheless transfer that right to somebody else completely, such that the counterparty then has to make the payment to a different person, not its counterparty. And then it went on to say in the premises that DIFC law applies, and then asserts that the assignment was an assignment within the meaning of the law, and then says by reason of Article 95, clause 3.1 was irrelevant. So I'll have to, there are effectively two parts to this. Firstly, which system of law applies to this question? And then secondly, once you've decided that, what does that system of law say? And the assertion is that UA law applies. Why? Because that's the law that governs the financing arrangements. And therefore, they say, the law that governs the assignment agreement. And we say that, firstly, the law that governs the assignment agreement is pretty clearly DIFC law anyway. But actually, that doesn't decide the issue. As a matter of conflicts law, where you have an assignment, and that assignment is governed by one system of law, but it assigns or purports to assign rights under a different system of law, then the question of construction, validity, effect of the assignment as between the two parties to it is governed by the law of the assignment. But the question of how that affects rights arising under a different system of law, say English law or DIFC law, that's a question of the law of the right. So you split it into those two parts, and that's a clear principle of English conflicts law. We've given you the authority references. It's referred to in the passage from Guest on assignments. And so, in a sense, it doesn't matter what the law of the assignment is, because we know that the law of the construction contract is DIFC law. And so if you're trying to work out what are the requirements for transferring the rights that we're concerned with, you have to look to DIFC law for that. And actually, it may be that is now conceded, because my learned friend Skeleton deals with only the DIFC law position. But there's another point here, which is what is actually the law that governs that assignment document, that so-called assignment? And we say it's very clearly it could only be DIFC law. Why do we say that? Because it refers to a trust relationship. So just to show you that, it's at page 127. We need to go back to 127 of the bundle. And you will see the final words, or the last. If we look at it's dealing with the payment of the monies due under the construction contracts, and the last three lines say the same immediately comes under your constructive possession while in the hands of the DIFC investments, and then it says who in this case is deemed to be your trustee in this respect. Now we know that trusts are not a concept known to UA law. And for that very reason, in the National Bonds and Talim case, the Court of Appeal found that a contract was governed by DIFC law, not UA law, because it referred to and purported to implement trust concepts. I can show you that case if you like, my lord. There's a very brief passage in it in Bundle F. And it's at page 105 of Bundle F, so F105. So we start at 104, paragraph 46. There was a question here. It was one of these Courts of Dubai questions. And the way that the Court of Appeal dealt with it was to say, well, the governing law of the contract must have been DIFC law. And so the meaning of the Courts of Dubai must be interpreted in that context and follow that decision. So 46, they're dealing with the governing law, paragraph 46 at the foot of 104. Given that the property underlying the tripartite agreement was located in the DIFC, and that the function of that agreement was to regulate the relationships between the beneficiaries under the trust, a legal institution unknown to the civil law administered in the non-DIFC courts of Dubai, but fully applicable under the law administered in the DIFC courts, it is to be inferred that the reference to the laws of Dubai in clause 14 was intended to refer to DIFC law rather than non-DIFC law. And it goes on to explain why. In 47, the punchline is, it's therefore to be concluded that the reference to the laws of Dubai in clause 14 was a reference to the law of the DIFC, not to the non-DIFC laws. So where you have trust concepts being referred to in this document, you have no express choice of law, but implicitly we would say that it just can only be a DIFC law instrument. As to what are the requirements, and I'll deal with both the DIFC law position and the UA law position, but I was going to deal with the DIFC position first. The requirements for an assignment are set out in the DIFC contract law, and DIB relies on Article 95 in particular. I've recited it in my skeleton argument, but I can take you to it in the authorities, whichever is easier. In the skeleton, it appears at page 13.
Yeah.
And you see it says, unless the circumstances indicate the contrary, a contract term prohibiting assignment of the contract bars only the delegation of to an assignee of the performance by the assignor of a duty or condition. So this is a rule of construction. This is the construction point. And the point that the effect of the statute here is that if the term prohibits assignment of the contract as a whole, then that is to be construed as prohibiting assignment of only the obligations, not as a prohibition on assignment of rights. That's the point. But of course, it's unless the circumstances indicate to the contrary, and it only applies if the contract term assigns the contract as a whole. And under DIFC law, sometimes they talk about novation, sometimes they talk about assignment, but it is possible to assign the whole of a contract. But the issue, the point here, if we go back a page in the skeleton, is that if you look at the assignment itself, or 2 pages to page 11, you see the assignment itself, and it expressly prohibits, without prior consent, assignment of the contract, but also of any part thereof or any rights, benefits or interests therein or thereunder. So it's express that it prohibits assignment of rights. And that's the end, we say, of the construction point. The second question is then whether or not, as a matter of law, this sort of prohibition is effective to prevent a transfer. And in this regard, if we go back to Article 95 on page 13 of the skeleton, what is, as I understand it, relied on is sub-article 2b, which says that unless a different intention is manifested, a prohibition of an assignment, 2b, gives the obligor a right to damages for breach of the terms forbidding assignment, but does not render the assignment ineffective. So on one reading, what it's saying is, well, the assignment survives the prohibition in the contract, but you have to read this together with Article 94 of the law, which appears just before on page 12, which makes clear that it can be, assignment can be precluded by contract. Article 94 says that in terms, implicitly at least. Article 94.1, contractual right can be assigned unless assignment is precluded by contract. So the one has to square these two things. the way you do it is to say that it is effectively the English law position, which is that where you have an assignment which has been entered into in breach of a contractual prohibition, that assignment is effective as a contract between the parties to it, but it's not effective against the debtor. It's not effective, in this case, against DIFCI, to transfer that right from one to the other. And as I say, that's consistent with the English law position. And as I understand it, from my learned friend's skeleton, that is conceded, because at page 12 of his skeleton argument, his 8th footnote, having recited the DIFC position, says the above principles broadly track the position in English law. And then we get the whole of chapter 22 of Chitty. But that plainly is the English law position. We recite some passages from First Abu Dhabi Bank. My learned friend refers to Chitty, which says very much the same thing. I can give you the reference, which is probably easier than going to it. It's at bundle G, page 50. And when you get there, paragraphs 22.045 and 22.046.
So is that Chitty?
That's Chitty. I've given you the reference. I can take you to them now if you prefer. I'm just we spent about an hour and a half dealing with the first issue, and I'm just a bit concerned we're going to run out of time. But and I don't want to run past the end of the court day. I'm about halfway through what I would want to say about the whole of the immediate judgment substantive applications. But the reference to the First Abu Dhabi Bank case, the relevant part is probably pages F370, and there's a quotation from a particular article by Professor Roy Good, and F372, and in particular paragraph 29, which cites the Linden Gardens Trust case. As I say, my learned friend refers to Chitty, which says the same thing, unsurprisingly, which is at G, bundle G, page 50, paragraphs 22.045 and 22.046. But the result, the effect is that an assignment, a prohibition on assignment is effective to prevent the relationship being changed as regards the debtor. It doesn't stop the assignment being effective as a contract, and that's how you square 94 and 95. And that must be right. If we go back to page 13 of my skeleton and Article 95, you'll see that what it says is at 95.2a, and this is a slightly subtle point, but it says a contract term prohibiting assignment of rights under the contract, unless a different intention is manifested. A is for the benefit of the obligor and doesn't prevent, 1, the assignee from acquiring rights against the assignor. So that's the point I was just making. It's effective as a contract. Or 2, the obligor from discharging his duty as if there were no such application. Now, the word application is clearly a misstatement, and you'll see what we say about it at footnote 6 is that application probably means prohibition, and that comes from the source for all of this, which is the secondary statement of contracts in the US. So it does not prevent the obligor from discharging his duty as if there were no prohibition on assignment. In other words, in this circumstance, where there's a prohibition on assignment, there's nevertheless been an assignment, the DIFC is not prevented from paying the bank if they want to. Now, for that to make any sense, it must be right that there hasn't, that the prohibition is effective to prevent a transfer. Because if there was a transfer, they would not just be permitted to pay the bank, they'd be obliged to pay the bank. So the construction in this way, consistent with English law, is the only way that makes it all hang together. So that's the DIFC law position. If the UA law applies, we say contractual prohibitions plainly are effective, or at the least there's nothing in UA law which says that UA law is different from DIFC law in that regard. And I was just going to show you one short passage from a case which you'll find in bundle F, page 281. And at 281, at the bottom half of the page, there was a dispute about whether there was a transfer of rights, and the court says where and said that there had, in this case, there had been a transfer, and the court says this challenge is apposite, as the transfer of right in which the creditor transfer his rights against the debtor to another person becomes a creditor in his place. Fortunately, the language is a bit garbled. Is originally applied to all rights, regardless of their place, unless otherwise stated by the law or the agreement or the nature of the obligation requires otherwise. So it's recognizing that if it is otherwise stated in the law or in the agreement, then it doesn't have that effect. And it says it is established under the judgments of this court that the transfer of right is considered permissible as long as there is nothing to prohibit or prevent the same. And this is concluded by mutual consent between the transferor and transferee without the need to the consent of the debtor. So the general proposition is that there's no need for consent unless there's something in law or in the agreement which requires it. The bank has now added 2 more cases to the bundle, I mean, you probably don't even have them if you haven't updated the bundle overnight, because they came in last night. We say that neither helps them at all. One actually supports the proposition that consent can be a requirement. The other is all about an insurer becoming subrogated to the rights of his insured. But I'll come back to those if and when submissions are made on them in due course. So as to the first issue then, is clause 3.1 effective to prevent a transfer if there's no prior consent? We say it is, whichever system of law you apply. Strictly though, it should be DIFC law applies, first because that's the law of the right that's purportedly being transferred. Secondly, because that appears also to be the law of the assignment. But either way, even if it was UA law, these sorts of clauses are effective. So then the next question is, was consent given? And there are 2 points here again. One is, was consent given at all? And then in the other is, was it given before the assignment? And if so, what's the effect of that? Or if not, sorry, what's the effect of that? So in the draft amended defence, 2 points are advanced for saying that reasons for why consent was given. And the first is that notice that you saw from January 2017. And the second was by making the series of payments into the designated account. As I see it from my own friend Skeleton, only the first point is advanced today. That's the notice, the acknowledgement. So we just have to look at the notice and see what it says. Does it consent to an assignment? And that's at page, just to go back to it, page C137. And we say the answer is pretty plainly no. C137, if you've got it. And I've already made the points really, but just to remind you, firstly, it refers to a purported assignment and says we haven't seen it. So it says nothing, it doesn't even acknowledge that there has been an assignment. Secondly, there's nothing in there about consent. And it is relevant that the draft that was sent to the DIFC in terms would have given consent if the DIFC had signed it. The draft is at page 134, 3 pages back, and it says, and we consent to the assignment. That has been removed. Thirdly, second paragraph of this document says, further to the letter, referring to the letter from BIC, And until we receive a contrary instruction from HLG, from the contractor, we will make these payments in this particular way. So in other words, they are saying we will do what our contractor tells us to do to make these payments. So until they tell us, they change their instructions, we'll pay it into this account or pay it into another account if that's what you want. Now, my learned friend's skeleton argument says that there's some sort of tension in the language here, because somehow you have to work out which takes priority, instructions from the contractor or instructions from the bank. In fact, there's no tension. It's very clear. We will do what the bank tells us unless and until our contractor says otherwise. So it's all subject to subsequent instructions from the contractor. That's a consistent document saying we'll do what the contractor tells us to do. That is inconsistent with there being consent. Certainly there's no consent in it. So that's really the beginning and the end of the question of whether there's consent. As I say, there was another argument that payments were made into that account, but that's really the same point. DIFC makes very clear why they're making payments into that account. They're doing so because they're complying with their instructions from the contractor. They're not consenting to rights being transferred. So we say the consent point is very clear, there was none. But all of this comes after the assignment, so there's no prior consent. And that is a requirement which has been held to be effective. But it's probably important just to see why those sorts of requirements are effective. It's because they nullify the actual notice that is given. And I can show you that in the Hendry and chart search case very shortly. It's bundle F, tab 17. And it's page 353. There's a discussion all the way, 351 to 353. Just confirms that it's essential that the lessor's consent is sought before the assignment is made. And I think they make the point, actually, not skeleton argument, but I'm afraid giving myself a note to the reference. But the reason why is because it nullifies the notice. And so if you accept that principle, that the consent needs to come beforehand, then that's the end of the question of whether there's actually been consent and whether there's been a contractual assignment. There is no answer to that point from DIB either. That is subject to the waiver and estoppel argument, which is the next issue. Again, I've rather advertised what I want to say about this, so I'll be very short. There is a pleaded case for waiver and estoppel, or waiver by estoppel, as my own friend says. Either way, it can't, we say, get off the ground for a number of reasons. First, there is a no waiver clause in the contract, or rather a written only waiver in the contract. That's at page C 123. And it's clause 62.12. No waiver by a party of any terms, conditions, rights, obligations, or breach of the contract shall be effective unless such waiver is in writing and addressed to the other party. And then it says, this is page 123, waiver by a party of one term, condition, right, obligation, or breach shall not constitute waiver of any other term, condition, right, obligation, or breach, unless otherwise specifically stated in writing and addressed to the other party. So you would have to construe the notice not just as consent, but as waiving the right to prior consent. But the second point is there would need to be, for there to be a waiver by estoppel or any kind of waiver, there'd need to be a representation. And again, the only statement that is relied on, as I see it, is the January acknowledgement, which I've taken you to a number of times now, or possibly the payments, but those wouldn't be in writing. So it doesn't take you any further than the argument that there has been consent. And then there would also have to be reliance, for which there's no evidence. There's an assertion in the pleading, but DIB would have to say that in light of those representations, it thought that there was an assignment, and it can't do that because it was fully aware that BIC was making the claims. So those are the submissions on waiver and estoppel. Just it doesn't take the case any further because it effectively relies on establishing consent. But there can't be any reliance on the facts given what we now know about their state of knowledge and what they were encouraging BIC to do. So that's the first sort of sweet category of problems with the claims relating to the requirement for consent, whether there's been consent, whether that requirement's been waived. The next category of problems is about what is the nature of this document? What is the nature of the so-called assignment? And we say it can't be intended to be a transfer of rights. Again, I've advertised most of my points on this, but I'll take you back, if I may, to page 127 of the bundle and just look a bit more closely at what this document actually does. And the first point is that it says, in consideration, etc., second line, paragraph 1, we hereby irrevocably and unconditionally pledge to you all the money due and receivable by us under all projects in the aggregate sum of 490 million dirhams. Now, in English law, of course, you can't pledge intangible property, but you can under other systems, lots of other systems of law. They have a concept called pledge, and then there's a specific one amongst other things under UAE law. But the effect of a pledge is not to transfer title. It's a form of security. So under both UAE law and DIFC law, there's a system for registration of those sorts of things that provides certain protections. And then there's also a statutory regime for vindicating your security rights. So there's a system for foreclosure on the assets that you have a pledge over, or that you have some sort of security right over. The position under UAE law, I can demonstrate very quickly by showing you just one case, if I may, which is at bundle F, tab 12. And it's at page 254 it starts, but if we go down to 257, F257.
Yeah.
And then it's about 7 lines up from the bottom. It says, whereas this pleading, do you have that? Whereas this pleading is inapposite, as Article 1477 of the Civil Transaction Law stated that the pledge may retain the thing pledged, or the pledgee, sorry, may retain the thing pledged until he has paid the full debt owed to him, together with all related accessories and expenditures, after which he has to restitute the thing pledged to the pledgeor, which indicates that ownership of the pledged movable property does not automatically transfer to the pledgee creditor by mere pledging, but rather it must return the same to the pledgeor after paying its dues. Therefore, it is not permissible to deduct its value from the debt owed by the pledgeor, except after taking judicial procedures to execute on the pledged property. And those judicial procedures, there's a federal law which we've included in the bundle. I don't think we need to go to it, but there's a system, as I say, of registration of the pledge and then execution of rights. So the effect of a pledge as a matter of UA law is no transfer of ownership. The effect is similar, at least under DIFC law. There's the little regarded DIFC security law, which there aren't actually any cases on. So rather than take you through the whole statute, what I'm going to do is just sort of say what I say it does, and then just show you some commentary on the source of that. statute, because it's based on the Uniform Commercial Code in Article 9, which is promulgated in the United States and various parts of Canada. But essentially, under DIFC law, there are various requirements where you have a security interest. There are various requirements for perfection of that security. Some of those involve filing. And then on default, the secured party acquires various rights. And amongst them, they can go to the debtor and require at that stage payment directly to them as a result of the provisions of the statute. So just to give you an example, we can look at this. If you go to bundle F, page 75. And you'll see Article 48 under the heading Chapter 2, Collection and Enforcement. Collection and enforcement by the secured party. And then after default, a secured party may notify a person obligated on collateral to make payment or otherwise render performance. Sorry,
not with
page 7, F75. Should be behind tab 3, I hope. Oh, you don't have tabs. More problems with the bundles.
Yeah.
It's a small point, and I won't
Okay.
I won't labour it. Yeah, so the short point was simply that, as I say, there's various requirements for what's called perfection of security. Some of them involve filing certain statements with the security registrar. But the way that the secured party vindicates their rights is not by having the secured asset, but it's by using the statutory regime for what's called foreclosure. Or taking the various rights, adopting the various rights that are afforded under these provisions. So, for example, Article 48(1)(a) permits the secured party after default, so you have to know that the debtor is in default, to go to the person obligated on the collateral to make payment or otherwise render performance to or for the benefit of the secured party. So there's a statutory right to demand payment of that receivable to the secured party, not to the party to whom it was originally owed. So it's perhaps a bit like a third-party debt order or something along those lines. That's how it juridically operates, but it doesn't imply or even envisage any kind of transfer of title in the assets. That is over which a security interest arises. And as I said, these provisions are based on Article 9 of the Uniform Commercial Code, which is a code that is adopted in one form or another in many different states in America. And so there is quite a lot of commentary on that. We've drawn your attention to an article by Planck, where he describes this as a lien paradigm, which he says is not about, and indeed is incompatible with, a transfer of title. That's in our footnote. Perhaps I'll do it there. That's better. So Article 9 embodies a security or lien paradigm that inherently assumes that the debtor, which includes an assignor of receivables, here BIC, retains an ownership interest in the collateral subject to a security interest. This security or lien paradigm is not compatible with the sale of receivables that by definition entails the transfer of ownership. Implicit in a lien statute is the debtor's continued ownership of the collateral unless it's sold at a foreclosure sale or a default. So if you're looking at this through a DIFC lens and asking what is the document, and you'll recall the document repeatedly calls itself something that's creating security. What's the effect of that in DIFC law? It's that if you go through the right hoops, registration and so forth, you get access to the statutory remedies. You wouldn't need those if you owned the receivable, because you would just go ahead and enforce it. So the dichotomy really is between, on the one hand, a security arrangement like this, and on the other hand, in essence, a factoring arrangement. So I can always go and sell my debts as long as there are no contractual restrictions on it. I can sell them out to somebody. But where you're dealing with a situation where a receivable is being used as security for lending, then under the DIFC regime, that doesn't contemplate, and indeed on the commentary is inconsistent with, an actual transfer of title. But more important than that legal backdrop, what is a pledge generally, what is security generally, is really the words of the assignment itself. And again, repeatedly it refers to itself as creating security, but I took your lordship to that passage at paragraph 4E on page C of 128, which requires BIC promptly to pursue remedies under the contract, which it couldn't do if it was transferring its title to those rights to DIB. And there are also in this undertakings about what DIB will do with the receivables. That's at paragraph 2. So those receivables will be paid into an account held with DIB, but it's an account of BIC. It's BIC's account.
Yeah.
Again, all of those undertakings are inconsistent with a transfer of rights or a transfer of title. So what you're seeing here is an arrangement which is intended to give the bank control over the receivables, which is a pledge type situation, not quite a possessory right, but in effect doing the job of a pledge, not to give them title. And that's clearly, as I say, how the parties understood it, because when it came to actually making those claims, it was for BIC to pursue them in arbitration against DIFCI. And that's what the bank encouraged it to do. And that is also relevant to the construction of the document, because you'll be aware, whether we're dealing with Dubai law or whether we're dealing with DIFC law, the way in which the parties subjectively understood the arrangement, if there's a mutual understanding, is relevant to the construction. And under DIFC law, you're actually obliged, when construing a DIFC contract, to look at post-contractual conduct in reaching your construction. And then the related point is the one about what notice was given, and the notice is at page 126, which is an assignment by way of security. Again, once you see that in the context of the right, which is a DIFC law right, against the backdrop of the security law, then you can see that what we're being given notice of is not of a sale of that receivable, not of a factoring arrangement, but we're being given notice of the creation of a security arrangement, which, as I say, is would normally be inconsistent with a transfer of title. So it's a related point. The two are likely to stand or fall together, but it is technically a separate question, what we've been given notice of. And that's really it on assignment. And we just don't see how that claim can work in the face of all of those difficulties. What we then have is a pleading and an assertion in the skeleton that DIFC Investments was a surety, a guarantor of BIC's debts. It's a bare assertion. In the pleading, you'll find it in page 26 of the bundle. And it's at paragraph 17. And all it does is assert that on the premise that UA law applies, the effect of the assignment was to place the claimant in a position of security with the meaning of Article 1077, such that it was obliged to make payments to the defendant. It is put slightly differently in the skeleton argument at paragraph 52. So in the pleading, it said, as a result of the assignment, DIFCI become a surety. In paragraph 52 of the skeleton, it said, if, as DIB contends, DIFCI accepted the said assignment, the effect of that was to place the claimant in the position of surety. So on one view, it's the assignment, on the other, it's the acceptance of the assignment. But either way, it's pure assertion. There's nothing, it's not explained. And we say there's nothing in it. The starting point is the civil code. I can show you this really very quickly, and I'm almost there in terms of submissions. Bundle F, page 249. An extract from James Whelan's book. This is chapter 5 of the Civil Code, which deals with contracts of personal guarantee and deals with suretyship in part 1. And the commentary makes the point, general overview, suretyship, kafala, is a contract of guarantee. So what they would need to show is some sort of contract of guarantee by which DIFCI promised to enter into that arrangement. And then the particular article of the Civil Code that is referred to both in the pleading and the skeleton is Article 1077, which you find on page 251, 2 pages down. And all that does is identify the obligations that a surety has. It doesn't explain how somebody might become a surety. So if it is being said that DIFCI became a surety, a guarantor, as a result of its acceptance of the assignment, this takes things no further than asserting that there has been consent to an assignment or there has been an assignment. And for all those reasons, it doesn't do that. But B, you'd have to look at that notice from January 2017 and interpret it as effectively a contractual promise to guarantee debts, which is not what it says on any view. I mean, one has to think about the commercial reality of all of that. I mean, why on earth would an employer guarantee the debts of its contractor? So there's certainly no material to support any case that there's some sort of contract entered into. That's all that's advanced by way of defence potential counterclaim. What then is left is paragraph 40 of the skeleton argument. And what is said is that 2 lines down at the end of that line, in addition to the question as to whether or not DIFCI's consent passed the threshold in clause 3.1a of the contract, it should be noted that subsequent facts give rise to a number of possible counterclaims which DIFC may assert in the event that the DIFC court is ultimately selected by the JJC as the appropriate forum. So these are possible counterclaims. They're not positively asserted. Now, just pausing there, the bank has already made its claims in the Dubai courts. It's had 3 months to make its counterclaim here, which it did, by the way, and then it withdrew it, or wants to withdraw it now. So it should not be enough, we say, to defeat an immediate judgment application to say that something might turn up. In any event, there is nothing in what is being said. Unfortunately, at paragraph 41.2, my learned friend says that the payment of, in particular, the 20 million dirham settlement sum might constitute a fraud by the contractor on DIB. Now, that is presumably raised to suggest that somehow DIFCI might be liable or participated in that fraud. It's unclear exactly what's being said. But either way, that is not an assertion which should ever have been made. It's not a properly articulated allegation of fraud. And it's very hard to see how there could be any case in fraud in these circumstances. If the payments were made in breach of the assignment, that would be a breach of contract, not a fraud. There's no, for example, there's no allegation of deceit in actually entering into a contract and inducing anything. There's no dishonest misappropriation of property. Because if there's an assignment, then the true assignment, then the receivable belongs to the bank. And so by paying 20 million dirham, the DIFC hasn't discharged its debt. So there's no harm done to the bank's property. If there hasn't been an assignment, well, then the bank has no property that could be stolen. So there's no arguable basis for asserting a case in fraud. The way, though, that it is then subsequently put is that there might be an argument for procuring breach of contract. And we say that, A, that doesn't get off the ground. So if there's an assignment, as I say, there's no discharge of the debt. But if there isn't, all that's happening is that DIFC is paying its debts. It's got to pay what is due under the construction contract, and its settlement of that is simply pursuant to that. There's no possible case, there's no case on procurement. Simply entering into an inconsistent contract with someone isn't enough. You need to procure their breach of the contract, and there's no case on that. There's no arguable case, and it has to be an unjust procurement. So where there's an obligation, simply an obligation to make payment to a party, then that's not going to be, payment of that is not going to be unjust. So the classic situation is where you have a bank account and somebody says, oh, well, I've been promised the money in that bank account. Well, the bank still has to follow its customers' instructions. It's not then liable to the third party for failing to do so, even if there's some sort of contract. And sometimes that runs as a response to whether there's an unjust procurement, and sometimes it sets up the defence of justification. But either way, there's a contractual obligation, then there's going to be no claim. But in any event, none of this arises because there's no counterclaim, even in draft. And it wouldn't be a defence to the claim, which is really about the assignment. Skeleton at paragraph 43 asserts something slightly different now, which appears to be saying that what they call the consent, the acknowledgement from January 2017, was a unilateral and enforceable promise. That requires the application of UA law. Again, that's not pleaded, but it requires the application of UA law, which probably doesn't apply. But it also requires you to interpret that acknowledgement as a promise to do things which were then not done. And given the acknowledgement always says it's subject to any further instructions from BIC, it just doesn't get off the ground. And that's really it. So what we say is really, and this particular passage, there's possible defences, possible counterclaims. They don't say defences, sorry, they say counterclaims. is a very good example of it. What we see is just a collection of really barely formed ideas, some of which are advanced, then withdrawn. Perhaps they'll be advanced again. We'll see what comes next. But none of them actually articulate a defence to the claim. And even if they were advanced, they wouldn't work. But they certainly shouldn't prevent you from reaching a conclusion on this case. My lord, those are my submissions, unless you want to hear anything further from me at this stage.
No, thank you. Mr. Birmingham.
Thank you very much, my lord. My lord, I'm going to structure my submission slightly differently, but cover much of the same ground. If we pull up, first of all, my lord, in section A of the bundle, tab, section A, page 8, to look at the relief which is claimed. That's my learned friend particulars of claim, and my learned friend is seeking immediate judgment on his items 1 and 2, which are 2 declarations framed in the way that they are. The basis upon which that is put is encapsulated in my respectful submission of paragraph 18 of the particulars of claim, which is the page before A7, in which it said no assignment that could affect the claimant's payment obligations under the construction contract has taken place because, and then there are 3 specific cases made, which in turn is what leads to the declaration sought. I intend to structure my submissions by going through each of those 3 premises from 18.1 to 18.3, because in my respectful submission, they provide a sensible approach to actually structuring the submissions. As part of those submissions, I will try and concentrate my time on those areas where I say it is most clear that there's a real prospect of success, and deal less shortly with the points which are more obscure. The first part of this can be dealt with relatively quickly. The first thing relied upon by my learned friend at 18.1 is that he asks the court to infer that there never was an assignment agreement dated the 29th of December 2016. That, I surmise, has now been dropped because we have put in a witness statement which actually contains such an assignment agreement. My learned friend hasn't said much about that, but clearly the inference can't be made, so 18.1 goes. That brings us to the first thing to concentrate then is 18.2, the suggestion that the assignment was waived security only and therefore could not affect a transfer of BIC's right to payment under the construction contract to the defendant. To deal with that, we will need to look at some of the documents again, and as you might expect, I will draw the court's attention to perhaps some other bits of the documents that my learned friend has not concentrated on. If we look then, first of all, on the assignment itself, which you have looked at before, and we have at page C127 of the bundle. And I'm going to make a number of submissions about this. My learned friend says, in essence, that this document should not be regarded as an assignment of legal rights, but rather an assignment that should be regarded as a pledge, as we see in his skeleton, and therefore something which created security over assets rather than something that transferred any possessory rights. I say that is wrong for the following reasons. Starting from the top downwards, the document is not styled in its heading as a pledge, but rather as an assignment. We look then at paragraph 1. The word pledge is used in the paragraph, and I entirely accept that. But what my learned friend has not done anywhere in his submissions, apart from paragraph 54, which we'll look at in a second, is deal with the important wording at the end of the paragraph. So it says, in considering of your granting and or agreeing to grant various banking credit facilities in our favour, we hereby irrevocably and unconditionally pledge to you all the money due and receivable by us under all projects in the aggregate sum of 490 million dirhams, in addition to any retention, compensation and claims, the receivable, once we become entitled to get paid the receivables. So that sentence is doing something very specific. It is creating an entitlement to us of some sort. We'll have to look at what the word pledge means. Once, not immediately, but once this contractor becomes entitled to be paid those receivables. As to then what that pledge means in context, we are told by the next two sentences that my learned friend did not concentrate on in his submissions. Well, it's one sentence, but we can break it into two. First part of the sentence says this: on the accrual of the receivables entitled to us, the same immediately comes under your constructive possession, while in the hands of DIFC Investments LLC. So immediately comes under your constructive possession, while in the hands of, and effectively, the claimant. Now, in my learned friend's oral submissions, and when dealing with what this clause actually means in his written submissions, I have to say I have missed any explanation of those words or how they are reconcilable with the assertion that this pledge does not give rise to any possessory rights. The phrase we see set out in the first part of that sentence is directly...
It's a complete mess, this, isn't it? I mean, the reality is that appears to be saying that there's a trusteeship on the part both of HLG and on the part of DIFCI.
I agree and accept that. That the second part of the sentence is what I think, my lord, provoked your and on the part of, and you're right. That is it is some form of.
But it isn't a transfer of title, because it's on the face of it a trust. Under your constructive possession can only mean that we hold this as trustee for you, and we're seeking by this arrangement, and no doubt an acknowledgement they hope to get from the bank, that the bank would hold as trustee as well. That's all it can mean, can't it? So
when you say the bank holds as trustee, do you mean DIFCI holds as trustee?
I did. I'm so sorry. Yes.
Don't worry. I thought that's what you meant.
I get so used to Mr. Montague Smith appearing for banks that I almost invariably assume that he does. But
no, I understand that.
It's you're the bank in this case.
So I am the bank in this case. So I would accept A, that this is a little bit of a mess, yes. But B, without doubt, what it is not doing is simply creating security over this. It may not be transferring the legal title, but at a minimum, it is transferring the equitable title, as we would know it as common lawyers.
Well,
and without doubt, equally,
can we just?
Yes.
I assume, therefore, you're accepting this is governed by DIFC law, are you?
I'm not accepting that. I see the point my learned friend makes about that. My primary submission is that this is an attempt by the parties to agree something that resembles a trust arrangement, right, but one under Dubai law. They're attempting to ape what you find by way of trusts under DIFC law, but they are doing so under UAE law. That is what they're attempting to do. And I'll come to in a second why I say UAE law should apply to this. But the first point is that what is happening here is not the simple creation of a security relationship. It is transferring at least part of the title, and we common lawyers would regard it as the equitable part of the title, to the bank to be held on a succession of trusts depending on who has the money. That is what it's attempting to do. And in my respectful submission, my lord, to defeat my learned friend's 18.2, that is all I need to show, because the key point of his "it's security only" argument is that it does not transfer any right to payment to us. And the answer is, well, it does, in fact, if we hold what we common lawyers would style as the equitable title to this.
Well, I understand the point in relation to the assignment. What about the point in relation to the notice of assignment, which is in slightly different terms?
Well, can I come to that? I promise I'm going to come to that. The other key point here is a timing point.
Yes.
And the timing point is when this all happens. And what you can see is that when this all happens is whenever HLG, as they're known, or BIC, establish that they are entitled to the receivables.
But one assume it would be on certification by the architect. It's accrual of the receivables, isn't it?
It is accrual of the receivables. Well, but the reason I say not certification by the architect is because, as you will know, having dealt in this context with more than one construction project, there are other ways in which it can accrue. For instance, parties can disagree with the architect, and they can.
Sure. But I'm giving that as an example. It's the whatever the entitlement is under the contract. It's the point at which you become entitled.
Exactly so, which in turn, and the reason I mention this is to try and deal with, you'll anticipate with some of the points my learned friend has made, which in turn explains why it is then left to the contractor to establish that entitlement. Because part, you'll recall, of what my learned friend, in fact, a significant amount of what my learned friend was saying is, well, this arrangement is inconsistent with the contractor setting out to establish that entitlement. If in fact this was transferring more than just security, we would be the people to have to establish it. And the answer is, well, no, you only have to read the document to see that the bespoke and slightly unusual arrangement entered into here meant that it was left to the contractor to set out to establish the entitlement. And when he'd established it, and it was when he established it, and the money was in my learned friend's client's hands, then they were a trustee for us. And if and when it moved to BIC's hands, they became a trustee for us. That was the bespoke arrangement.
How is this really going to work? I mean, the effect of it, it seems to me, is that it must operate in the nature of a floating charge, because once the money goes into the account, it's plain it isn't simply being snaffled by the bank. It's going to be then used by BIC for its own purposes, isn't it? If it had been snaffled by the bank, all the debt would have been repaid. But it's like a floating charge.
Like a lot of food. So in terms, the reason I'm slightly concerned, as you might anticipate, by the suggestion of, well, isn't this like a floating charge, is that it may share some of the, in terms of how it would operate in practice, it may share some of the practical realities of how you'd operate a floating charge, but it is conceptually different, because by definition, the parties have agreed this wording in their bespoke arrangement, which makes it clear who owns possessory title to the monies at given points, which is different than a floating charge.
The difficulty is that this is a mess, because we've got constant references to security interests, security created, and on the other hand, assignment of receivables is unconditional, final, and irrevocable. So, I mean, I'm very loath to make any very clear findings about what this arrangement really consists of, but I doubt at the end of the day that it's going to matter.
Well, it concerns me that you say that. Let me just develop my submissions a little bit before you.
I'm sorry, I should let you finish, but you're obviously aware of the difficulties of actually working out what this document is really saying, and indeed how it worked, but which I don't think I have any actual evidence. I don't think the witness evidence deals with how this actually operated in practice at all, does it?
No, save that. We know that how in fact it operated in practice was up until the very last payment of 20 million dirhams. The payments were indeed, sorry, and my learned friend's right, the very first payment, which was an advance payment, but for the vast majority of the time, it actually operated in the way it appears to have been intended to operate, which is that the payments were made into a bank account operated by us, against a background, if you look at the facility agreements themselves, against a background of the facility agreements being updated as the years went on, with new figures being offered and what those figures have been offered for. So in terms of, I mentioned that not to sort of make a particular point on it, but rather to answer my Lord's question of, do we know how in fact it was operated? And the answer is, well, we do in fact know how it was operated. It was operated in a way that meant my client got the money and had control over the money and could decide whether it wished to let HLG use the money right up to the last minute, whenever this final payment was suddenly transferred to an account that wasn't an account that we had. But that's the only other thing really to show you then is in relation to over the page at C128. And again, I'm not seeking to demur from the proposition that this is an unhappy document. Under F, it says, neither the security created by or pursuant to this assignment, nor the rights conferred upon you, nor any of your nominees, shall be discharged, impaired, or otherwise affected. So again, it clearly isn't just security that's been dealt with here. There are specific rights that we are being given, which are, if one is to adopt the view that the wording is intended to achieve something, are differentiated from and dealt with separately from any security which is offered.
What do you say the word security mean in this agreement?
Well, I say that there is security given by the fact that when you operate paragraph 1, we are given constructive possession of these receivables. So there is security in a practical sense in that we're given possession of them. We can then decide what we're going to do in relation to those monies, including whether or not to lend them back out again. So it is security in a commercial sense of us actually being given possessory rights over these monies. And I say,
I haven't looked at the facility agreements, but no one has told me that those make any provision for what actually happens to the money once it's paid into the Amanat account.
It doesn't specifically set that out. It's probably sensible to look at the facility agreement, which you will see, my lord.
It was why I was saying I don't think I've got any evidence about how it operated in practice once the money has got to the Amanat account, and who therefore controlled it. And that's why I used the expression floating charge, which may not be entirely apposite. But it appeared to me the likelihood was that that was the way the arrangement operated in practice.
So you're absolutely right that there is no witness evidence that sits down and explains it. But it is, in my respectful submission, possible to infer how the parties operated this by looking at how the facility agreements were modified and changed as time went on.
Okay.
So if you look at C1 in the bundle, you will see at C1 a sheet of paper with some Arabic writing on it as a heading, and the meat of it in English is at C2.
Yeah.
At C2, you will see the first and original version of the facility agreement letter. And you will see under the little box setting out the original type of facility, you will see there's purpose of facilities, and then under a heading securities/support/collaterals, it says for all the obligations of the client to the bank, the following security will be provided, and then says irrevocable assignment, so not pledge, using my learned friend's word he picked up on, of project proceeds in favour of the bank to a project-specific Amarat account with the bank or to the security agent bank as may be applicable. Then 2, notice of assignment of project proceeds in favour of the bank to a project-specific Amarat account of the bank to be advised. So that's how the assignment, which is then created, is explained in the facility letter.
Is the expression Amanat account a technical term? Not one I come across.
I don't actually know if it's a technical term. Maybe those who instruct me can email me with some instructions on that. I'm not sure. But what you can see happening then as we go on, if you, for instance, you turn to C7, you can see, and you'll recall, we've just looked at the facility agreement letter dated the 27th of March 2016. At C7, you can see there's an updated facility agreement in which you can see it refers back to the original facility letter and says, please be advised, we've renewed your banking financing facilities as mentioned hereafter. And then there are specific limits given for specific projects, including sub-limits and timings for repayment and so on. And as you continue through C10 and C11, you can see the same thing happening. And so, again, to directly answer your question, one can see that whenever you team this up with the fact that we know that the money was, in fact, over this period being paid into the bank account, you can see that what is happening, in my respectful submission, is the receivables which are received are paid into our bank account, and we then re-lend monies out. Now, that, of course, has some features which are similar to a floating charge. But all of that, in fact, whilst having features which are similar, all of that is entirely consistent with the fact that whenever the receivables are paid, they are paid to us and we have possessory rights over them. And then we are lending the money back out again. That is on the face of the fact that the sums are paid, and on the face of the fact that we can see from these facility letters what is happening, i.e. as time goes on through the years, some of the money being paid, being lent back out again for different projects and so on. That is all consistent with that. So that's why I say the starting point here is that the learned friend's case at 18.2 is not correct, or at least applying the test to be applied at this stage, we have a reasonable prospect of success of showing that on a proper construction of this agreement, it is not correct to say that all that's happening is the generation of a right to security as opposed to possessory rights, which we can then rely upon. the simple fact that there is the trustee language I have mentioned in the assignment itself, and my respectful submission is fatal to that. That brings us to 18.3, which is all to do with.
Before you get there, can I just check? The facilities last for how long? Each of these facilities.
Well,
General limits, the project limits.
yeah, the answer is that there's an overall facility agreement letter that then breaks down into various projects. Sorry, breaks down into various subsections of main limits and sublimits with different lengths, which are called tenors, being applied to each of them. And by the time you get, for instance, to C7, you can see the original 300 million dirhams from the facility letter remaining in place, but then a new agreement being reached setting one-off project-specific limits, which again set specific limits for project. In this particular one, we can see the project we're talking about, the Dubai International Financial Centre Gate Avenue, and we can see that there's specific limits being placed for those, some limits placed for those, and then specific lengths of time for which that's going to be made available. Similarly, if you, for instance, go to C10, you can see other projects receiving similar treatment in terms of specific credit limits being applied to them. In this case, the FACUS Academic Medical Hospital, the Dubai Silicon Oasis project. So what you can see happening, my lord, is a starting point of a general facility letter, which when it starts in March 2016, is an overall limit with some sublimits applied, pursuant to which there has to be irrevocable assignments of project proceeds and so on. And as the years go on, that then becomes more refined and more sophisticated, with sublimits being applied for particular projects and monies being lent out on that basis. And not only for particular projects, but specific tranches of lending for specific projects with different time limits being applied. That, we say, is inconsistent with a more general and less nuanced approach of, well, all that's happening here is that there is some security being taken over some proceeds. It is a much more sophisticated approach than that these parties are agreeing. And that in turn may help explain the odd nature of what they are seeking to agree. And in particular, what they're seeking to agree is this idea of us getting security with a small s for our role in the project by taking possession of the monies when they're in the hands of DIFCI, because that's the biggest project, and then when they come into the hands of the contractor itself.
But in terms of repayment obligations, I'm still trying to work out how this really works, but I find it hard to believe that on a 24-month facility in relation to the project, and it appears to be pretty much the same for the other project as well, the hospital. Yeah. That when money is received on the project, it's not effectively security for the repayments that are due. under the loan. I appreciate this is an Islamic arrangement, and Mahab loans, I'm going to say, is what, but
the concern I have with, or the point of differentiation between how I put it and how my lord has just put it is simply this. What in fact is happening with this money is dictated by what the assignment of project proceeds is that the parties have agreed. Standing back and looking at it, it is clear that, let me put it this way, stand back and looking at it, it is clear that this borrower and lender are trying to achieve a position where the lender will make available to the borrower monies so the borrower can get on with his projects.
Yep.
And the lender is trying to achieve a position where it feels safe and able to do so. Now, there's a number of ways in which they could have sought to achieve that. One was simply agreeing a form of security over those monies. The other was creating an alternative way of doing it, whereby the bank actually was given possessory rights over those monies as they fell due to the contractor, so that it could then make a decision about which of those monies it had possessory rights to recycle back into the project, or to not recycle, as the case may be. It's clearly open to them to agree whatever they want to agree.
Yeah.
On the face of it, on the face of this letter, and in particular the long sentence at the end I broke into two, and brackets, which my learned friend hasn't, in my respectful submission, grappled with, close brackets, they agreed the second. They agreed a arrangement whereby, to ensure that we, the bank, had maximum control over these monies, we were given possessory rights to them, on the basis that the contractor would undertake its role of establishing, the monies to be paid to it, and whenever it got the monies, we would have constructive possession of it, and whenever they'd established entitlement to it, but they hadn't yet got it, Dubai International Financial Centre Investments would act as our trustee. Now, that is, I would concede, a slightly unusual arrangement. It's not, I can't say I haven't seen anything like it before, because I have, but I would accept it's unusual. But that's what they agreed. Now, my lord said to me a second ago, well, that's all very well, but does that help? And so I'm keen to understand which point in particular my lord is troubled by. Of course, you haven't made a decision yet until you've heard my submissions. But what is the particular point that troubled my lord such that he said that, so I can then concentrate my submissions on that point or points?
Well, at the end of the day, it's what was acknowledged by DIFCI.
Right. So
it seems to me that everything really turns on that.
Okay. Well, let's. I agree that is central, which is why
the other point I was asking about, which I think is less important, is the actual notice of the assignment, which is obviously much more limited in its terms, but which was all that DIFCI received until they eventually got a copy of the assignment with your defence.
So let's look at that. The notice itself, you will see at C129.
Yeah.
Now, there's a couple of points about this. The first point to make. Yeah. The first point to make is that the only reason, there is no suggestion that DIFCI, having been told that there had been this assignment granted, the only reason there is no suggestion that it asked to see the assignment and were refused. Right. So whatever it's, to use the words it used in this document, whatever it acknowledged and consented to, because that's the word it used in its document.
Yeah.
It was acknowledging and consenting to something which it may not have seen, but that's not because it had been refused any inquiry to see it. It is because it did not make such an inquiry and therefore did not see it.
But that doesn't take you far enough, does it?
Excuse me, my lord?
It doesn't take you far enough. You've got to look at the wording, never mind the heading. I agree, some significance has to be given to the heading.
Oh, no, I'm going to go through it virtually line by line. Don't worry about that, my lord. So the notice of assignment gives them notice of the document you and I have just looked at. The second paragraph says, we hereby irrevocably and unconditionally authorize you to make payment of the receivables to that account or to such other account as the assignee may at any time notify in writing to you.
Yeah.
So that's important. That is pointing out that the control that is irrevocably and unconditionally notifying the DIFC that the control over where money has paid has now been transferred to my client, and it is doing that irrevocably and unconditionally. The last paragraph draws attention to some important bits of that assignment, which is that it's pointing out that pursuant to the assignment, BIC are not entitled to either assign, transfer, dispose of, or permit to exist any security, interest, or other encumbrance on or over the receivables. So that is putting, not only is the assignment itself specifically flagged up, and not only is the effect of the assignment being that control over the monies is being passed irrevocably and unconditionally to my client, but it is also saying, just to, if you like, underline that point about control, that HLG are now not allowed to do anything at all with respect to those monies. Not entitled to assign them, to transfer them. It's not entitled to dispose of them or to permit to exist any encumbrance at all over them. So faced with that, the key document is, as my lord has said, the document we find at C137. And as I say, we're going to look at this, as you would expect, carefully. There is some important factual background. The first part of the factual background against which this document is to be construed is the notice which we have just looked at. That is a notice that makes clear that there has been an assignment entered into, and so it exists if the claimant wishes to see it. Now, it didn't offer it to them, but it makes it clear to the claimant that there is a document in existence that if it wishes to see, before it wishes to acknowledge and consent to the assignment, it can do so. So that's the first part of the factual background. The second important element of factual background and context to take into account when we construe this document is that even if consent is required under the building contract, the form of that consent is not specified. So all that is needed is a manifestation of consent. That's apart from the prior point, which I'll come to a little bit later. But in terms of what the document has to look like, there is nothing specified. The third bit of important factual background to look at, to construe this document and what acknowledgement and consent was being given, are the documents that led up to it. We have seen the document at 129. And we have seen that that document expressly refers to the assignment, my lord, that you and I have already looked at. The next document is, which is important, is at C132, which is of a letter of 15th of January. That letter refers back to the notice of assignment. and asks that the attached acknowledgement, consent and undertaking is signed. That acknowledgement, consent and undertaking is at 134. And but what is important, therefore, when you read both the letter of the 15th of January and the acknowledgement and consent and undertaking that accompanied it, is that it is clear in my respectful submission beyond debate that what the letter of 15th of January is asking for is consent to the assignment of the 29th of December 2016. So that is what the letter is specifically asking for. That is clear from both the letter itself and from the suggested terms of the acknowledgement and consent. Now, what of course the defendant could have done in that situation, sorry, the claimant could have done in that situation, is a number of things. It could have refused its consent. It could have said, we are not either acknowledging or consenting to this assignment until we have seen it. Or it could have acknowledged and consented to the assignment without troubling itself to ask for or to see it. And in fact, without troubling itself is perhaps, given the wording of the document that then emerges, perhaps the wrong way to put it, because there's a fourth thing it could have done. It could have acknowledged and consented to the assignment whilst choosing not to ask for it or to see it. And it is clear on the face of the documents that that is what it did. And we know that from the document that it then sent back. So the document it sent back, you will see at C137. So having gone through the contextual background to this document and having seen the lead up to it, that lead up being they were given notice of the assignment, they didn't ask for it. They were specifically asked to sign a document consenting to that assignment, and it was entirely clear that that's what they were doing, and they didn't ask for it. We then get the document which we see at C137, which is the key document. There are some important features to this document. Firstly, as you can see from the attachments at the bottom and the first two lines of the acknowledgement and consent, this document not only specifically refers to, but specifically appends as an attachment the letter of the 29th of January, which we have already looked at, and by which notification was given. So that is a letter which is specifically referred to and specifically attached, and therefore forms an important part of the context of this letter against which it is to be read. The second thing which is important is that it is addressed to DIB directly. The third thing which is important, and it is important, but as you can hopefully now see, I don't put all my eggs in this basket, is that it is headed acknowledgement, consent and undertaking. Two questions immediately arise from that. What is it acknowledging and what is it consenting to? Because those words have to be given some meaning. The answer is given from what I've just said. It is acknowledging and consenting to the document which we have called an assignment, which is being specifically referred to in the letter of the 29th of January 2016. How do we know on an objective construction of this document that that is what's consenting to? Well, firstly, because it attaches that letter of the 29th of January, sorry, 29th of December. Secondly, because it specifically refers to that letter of the 29th of December. Thirdly, because having taken you through the sequence, you can now see that the if you look back at C134 at the original version of this document and the letter that accompanied it, it is clear that what they were being asked to acknowledge and consent to was that original assignment of the 29th of December. Fourthly, they do not in either this acknowledgement, consent and undertaking letter or in the letter which accompanied it seek to suggest that they're acknowledging and consenting to something different than what they'd been asked to acknowledge and consent to. And the last point is, of course, that they are doing all of that against a background of having been told in terms in this letter of the 29th of December 2016 that they were irrevocably and unconditionally authorizing payment of the receivables to the particular bank account being run by my client, the Dubai Islamic Bank. So you take all of that together and you put it in the scales, and in my respectful submission, everything from the heading down to the specific reference to the 29th of December and the context in which this is written makes it clear that they're acknowledging and consenting to the document called the assignment that they had been specifically notified about in the letter of the 29th of December. And it does not help them one jot, in my respectful submission, that they chose not to ask for a copy of that document before they acknowledged and consented to it. They were perfectly entitled not to. What they're not entitled to do is say, well, we never asked for it, and so our acknowledgement and consent to it doesn't count. Business people all the time keep lawyers busy by agreeing to contracts without having read them properly, by consenting to things without having taken the time that in fact they should have taken to ensure that they fully understood what they were consenting to. But it doesn't help those businessmen, and it does not help DIFCI to now say, well, okay, we've no other candidate for what we're acknowledging and consenting to, but we didn't read the document that we had been notified of, and so we can't have consented to it. And that's added all the more to by, and it's a point I said I'd come back to a few moments ago, just before the yours faithfully in the letter, it says, we further acknowledge and have had no sight of the respective parties' obligations to one another in the assignment agreement, which has not been provided to us. That they clearly thought that helped them at the time in some way, but it doesn't, because it demonstrates that what they are acknowledging and consenting to is the assignment agreement. And that wording is obviously there to demonstrate that they have made a choice not to ask for it, because presumably they think it helps them in some way not to have asked for it. So that point takes care of the purportedly in this document. The learned friend relies on purportedly and relies on the proviso further to the letter until we receive a contrary instruction from HLG. Our point in relation to this is relatively simple. and it's really a threefold point. As we say, the context of this, as you've now seen, is that HLG had been told that DIFC had been told on the 29th of the 12th, that what was happening was that they were being irrevocably and unconditionally authorized to make payment into this account. They make specific reference, as I say, to this letter, and so they clearly understood that. The wording further to the letter and until we receive a contrary instruction from HLG, combined with the fact or such other account as you may at any time notify us to us in writing, the you in that situation being my client DIB, is relatively simple. The way one resolves that conflict against a background of the irrevocable language, which this letter is referring back to in its reference to the letter of the 29th, is to work on the basis that further to the letter until we receive a contrary instruction from HLG should be understood as being receive a contrary instruction from HLG on behalf of Dubai Islamic Bank. Because that's the only way the irrevocable works. And that's how you reconcile the first proviso with the second proviso, or such other account as you may at any time notify to us in writing. And my learned friend says that there isn't a tension. Well, there clearly is, that unless you resolve it in that way. And the tension is this: what about on a Monday morning? The bank opens its post to find that there is a letter from Dubai Islamic Bank saying, in fact, can you pay this money into this slightly different account? And a letter from HLG saying, oh, on our behalf, ignore what Dubai Islamic Bank say. We want you to pay this into a yet further account. There is a clear tension there. Which of those two instructions is the DIFCI to obey? Well, that is resolved by recognizing the DIFCI, as part of the contextual background to this and specifically mentioned, have been told in terms that HLG cannot issue contrary instructions to them to pay the money away from my client. Their instructions have been irrevocable. And so the wording in this paragraph is making clear in my respectful submission that the contrary instruction from HLG, that's anticipating an instruction from HLG on behalf of Dubai Islamic Bank. And my respectful submission, that's how that letter works. In all the submissions my learned friend made about this letter, he did not deal in any way with the references back to the letter of the 29th of December twice in the letter. He did not deal in any way with how one deals with the fact that that letter brought in as part of this new letter makes clear that HLG are not entitled to, of its own bat, change the authorization. They've given irrevocable instructions. And that, at a bare minimum, for the purposes of today, my lord, must create a proper arguable case with a real prospect of success, that by this acknowledgement and consent, these people were acknowledging and consenting to the very assignment document which they had been given, and which they refer back to by means of their Appendix A in reference to the letter, and which they had been told had the effect of creating an irrevocable instruction on behalf of HLG as to where the monies were to be paid. as always with council submissions, one can ask the question in rhetorical ways. If that was not what they were acknowledging and consenting to, then what were they acknowledging and consenting to? If that is not what they understood they were acknowledging and consenting to, why did they make repeated reference to and append the letter of 29th of December? And if that's not how this is to be construed, how is that reconcilable with their objective knowledge that we take from the letter of the 29th of December, that HLG were giving them irrevocable unconditional instructions that the monies were now under the control of my client, the DIB? Because pulling the threads together, that's the key in my respectful submission. It's about control. Who was in control of where these monies went? And the effect of the assignment, we say, is that we're in control of it. The effect of the notice, no matter what else one says about the notice, is that DIFCI are told in terms that they're being given irrevocable instructions. So they were given irrevocable instructions that they were to make the payment into a particular account or to such other account as we may in time notify in writing to them. So HLG are making it clear in terms that the control of where the money went to us. And the acknowledgement and consent was in terms making clear from DIFCI that they were relinquishing control over where this money went. Because the second paragraph makes clear that whoever was entitled to decide where the money went to, it was not them.
Well, there's one word you haven't focused on in the notice of assignment, which is the word authorise as opposed to instruct. We irrevocably and unconditionally authorise you to make payment. Now, that isn't actually the same as instruct, is it? But bear in mind, I have the point that they haven't asked to see the assignment, but they haven't got the assignment. What they've got is this notice of assignment and then an acknowledgement as a Schedule 1 that they're being asked to sign. Well, in fact, rather oddly, I don't think the letter refers to the Schedule 1 attached, does it? It actually simply says, please acknowledge receipt of this notice. But attached to it is the schedule, which one assumes they would have understood they were expected to sign. And of course they don't in the end. They have their own form of words, which they then send back.
So you're right, I had not focused on the word authorise as opposed to instruct. But so you have to read the word authorise as in context, but in particularly in the context of the words which complete that sentence, which are or to such other account as the assignee may at any time notify in writing to you.
Yeah.
So I think that does make good my control point, where if you read it in context.
Well, it does until you come to the letter that's then written by DIFCI, because they are accepting that essentially as an authority to do so, and they say until we receive a contrary instruction, they have authority to do it. They're not accepting as an irrevocable instruction to do so. And that's the reason I asked the question. And I entirely understand you've got to read everything in context. Context is everything,
but the point is that they have been told in terms, and it isn't that things are changing, because my point is they're making specific repeated reference to that same letter.
Yeah.
They've been told in terms that HLG cannot change this authorization. It's an irrevocable authorization. And it's an irrevocable authorization to send the money to the account, to send that money to that particular account or such other account as we may at any time notify in writing. What that doesn't leave room for, in my respectful submission, is them to go back and certainly without spelling it out, say, well, we're not taking that as an irrevocable authorization. We're taking that as a revocable authorization to send it to that account. And the other wording that one has to read authorize against is the last paragraph of that letter of the 29th of December, which is again making clear that that money going into that account, HLG are not entitled to do anything with that money. Not only are they not entitled to assign it, they're not entitled to transfer it to another account. They're not entitled to dispose of it or to create any security over it. So you take those things together, and in my respectful submission, the real question is not whether they were disobeying the irrevocable authorization. The real question is whether, reading this in context, we are to take this on an objective reading, given all of that context, as DIFCI saying, well, we're taking that authorization as revocable, or whether it should be read as saying, we are taking your HLG's authorization as irrevocable, but of course you've told us that the bank can tell us to transfer this money wherever they want to transfer it. And in my respectful submission, that is the correct interpretation on an objective basis of this letter. Because the alternative, my lord, is that they are not acknowledging and consenting to the assignment at all. They are making a counter proposal as to what they're going to do with this money. And it plainly is not a counter proposal. Or, sorry, on an objective construction, it cannot sensibly be construed as a counter proposal. Now, the one bit which is left over on that particular point, because I agree that this point is central. It's one of those cases where if you're just not going to be with me on that, at least this creates a proper, reasonable case that we can run, then you may not be with me on other points. So that's why I've concentrated on this, and I said at the start I'd concentrate my time. But in my respectful submission, there's nothing in the prior point. If you agree that this is them being told, well, go back a step. The DIFCI take no point about there hasn't been a prior request for their consent before this assignment, right? That the first time that point is taken is whenever this dispute emerges. They are told there is an assignment. They're asked in terms to consent to it, and they do that in writing. And in my respectful submission, insofar there's anything in the prior point, they are ratifying the assignment and they are waiving the requirement of priorness in relation to their consent. These are commercial parties. They could have taken the point if they wanted, and they didn't take the point. So there are obviously a load of subsidiary points, because how you get to the point of looking at the consent and whether or not you have to look at it depends as to whether or not you go down the DIFC law route or the UAE law route. But can I just very briefly try and grapple with those points? I said in particular I'd come back to the UAE law point, and I have the point obviously about the fact that it refers to concepts which are more obviously common law concepts, such as one finds in the DIFC isn't quite a common law jurisdiction, but my lord understands what I mean by that.
Yeah.
As opposed to the UAE. But to be placed against that, if we look back at the facility agreement and we look back at C2, both parties accept, I think, correctly, that if you look at C6, that the choice of law is clearly intended to be onshore law, the UAE Dubai law. If we look back then at C2, one can see that a key point here, a key part of the consideration for under this agreement is the irrevocable assignment of project proceeds. That is why we say that the legal system more closely connected to both the assignment and how the consent to the assignment should be construed is the UAE rather than DIFC. And again, I try and make that submission by asking a rhetorical question. Given that both the given that the assignment and notice of assignment are dealt with 1 and 2 are key parts of this facility agreement letter, what legal system is one to apply in order to ascertain whether those requirements of this facility agreement letter have been complied with? To which the answer is the UAE. You know, if we wished, if we wish to debate with the other side about with the HLG about whether or not they had complied with this, the question of whether or not they had complied, they had granted an irrevocable assignment of project proceeds of the cert required by this agreement, or notice of assignment of project proceeds of the cert required by this agreement, is clearly a question that would be answered in my respectful submission by the application of UAE law to those documents. Their genesis is this facility agreement letter. Whether or not they comply, whether or not they satisfy HLG's obligations is a question of UAE law applying this agreement. And it's for that reason why I say UAE law does apply to this. Can I just, in the time of available to me, just concentrate a little more then on the Estoppel point? Because in terms of Estoppel and waiver, as with all Estoppel arguments, my experience since starting this job some years ago is that if you don't get home in the contractual argument, Estoppel seldom saves you. But this is a slightly unusual agreement in my respectful submission. Sorry, a slightly unusual position in my respectful submission for 2 reasons. Firstly, because of the factual background that I have just given you, in which you have seen how the how DIFCI came to give us acknowledgement and consent. And you've seen it comes from being specifically asked to acknowledge and consent to the assignment that we have seen. If you take the view that, in fact, when you look at their words, you look at the words they've used, it doesn't quite amount to that. In my respectful submission, the words that they did use in this contractual background do amount to a representation that they are going to comply with the assignment that was given. And so if ever an Estoppel case does arise where a contract falls short, we say it should be here. Now, against that, my learned friend has got 2 or 3 points. First, he says, well, there's an anti-waiver provision in the contract which says that it has to be in writing. Well, the acknowledgement and consent is in writing. All the transfers of money that were then made under that acknowledgement and consent were all made in writing. No money is being transferred from one account to another without payment instructions being sent out and those payment instructions being acted on. And the second point he made is, well, how can they establish estoppel and waiver in a situation where we were looking to HLG to actually establish the money by means of its arbitration and so on? And I hope I've dealt with that by looking at the particular bargain these parties made, which did envisage that that's exactly what AIG would do. They would set out to establish the money, and when it established it, then possessory rights to it would become ours. And so, in my respectful submission, there is a proper case made out in terms of estoppel and waiver. My lord, there are other points of detail. Let me just deal with them relatively quickly. If we're right about UAE law, what we do say about UAE law is that the requirement for consent is downplayed in the UAE law cases and notification is played up. I'm not going to take time to go through the two cases which we have put forward. I entirely accept that those cases talk about, in some parts, talk about assignments being valid if there's nothing to prevent them. But equally, when you go through those cases, my lord, you will see an emphasis being placed on notification of the assignment being what is important. And I can't really take it much further than that in terms of those two cases. And in terms of the DIFC law issues, I've dealt with the consent issue. My lord, that's all I was going to say about the DIFC law issues. My lord, I've tried to concentrate my time on the issues in particular where I can see that in an application like this are the most important ones. But if I can help you further in any of the other issues, I'm very happy to.
No, I don't think so. Thank you very much, Mr. Brannigan. Very helpful. Thank you.
Thank you.
My lord, I'll be very brief in reply, if I may. Firstly, I just highlight that throughout my learned friend's submissions, and indeed as a result of those, compared to how the case is put in the pleadings and in the skeleton argument, what you are really faced with from the defendant is a series of mutually inconsistent cases. So on the one hand, you've got an assertion of an assignment, that is an assignment under DIFC law, not an English law assignment, equitable assignment or anything of that sort. There's no concept of equitable assignments as a matter of contract law under DIFC law. It doesn't operate in those terms. There's a particular provision of the contract, DIFC contract law, which is based on the unidroit principles, not on English. It synthesizes the effect in some regards, but it's quite different in others. So what is alleged is a DIFC law assignment or a true assignment, that is an assignment of title. And then you get this allegation, well, actually, there's a declaration of trust. And then you get this allegation that perhaps there's a possessory right. Just starting with that, my learned friend started his submissions by emphasizing a dichotomy between, on the one hand, a security right, and on the other hand, a possessory right. That is not the dichotomy that you're interested in, because obviously a pledge, for example, of shares or a pledge of some object can give rise to a possessory right, but it's still a security right. It's still
that's exactly what it is.
Yeah, exactly. Well, quite.
In English law terms, at least.
Yeah, quite. But just focus back on the complaint that is made against my client. So this is obviously a claim for a negative declaration, but what is the claim that we are faced with? It is that while we entered into a contract with the contractor, we were not entitled to settle the contractor's entitlements to us with the contractor. and we were not entitled to pay the contractor the sums that were due to it. Now, this is said to arise out of an agreement between the bank and the contractor. And ordinarily, privity of contract, that's a matter for them. So there has to be some way of making that agreement bite on DIFC investments. And the way that that was said to work was because there was an assignment. And so if you look, for example, at their skeleton argument, paragraph 49, it relies on Article 99 of the DIFC contract law, which says that once you've got notice of an assignment, true assignment, you can no longer deal with your rights as against the original party. You have to deal with them as against the new party. And that's because title to the interest passes. So it's all about that title. That's why my submissions were focused on title. Who has title? Because that's where the case has to go. Because now what is being said is that, firstly, that there's some sort of possessory right. Well, that's not enough. If they don't actually have possession of the object, I can still deal with the owner. I still vindicate my obligations to them when I engage in a settlement negotiation. I can still settle those off because it's only a title issue. It would only be if the contractor no longer had title that I wouldn't be able to engage with them. So then what we get in submissions is this new argument that it all turns on the words at the end of that sentence, paragraph 1, of the assignment document itself. And again, I mean, your lordship picked up that the case is internally inconsistent because we know that there's no such thing as a trust under UAE law, but yet my learned friend says it's a UAE law document. All right. But the question becomes, well, what do those words mean? So if we take those words out, this is clearly a pledge. It's page 127, C127. If you take those words out, this is clearly a pledge. It says throughout that it's creating a security. It says that in terms. The security, for example, 4B, we've got the power to enter into these obligations and to create the security described herein. C, no security interests brackets other than this assignment. So this is a security interest. So if do you have to upset all of that and say, well, actually, no, this is more than security? If so, what is it as a result of these few words at the end of paragraph 1? And so the question becomes, well, what do those words actually do? And the answer to that is probably nothing. And that's all the clearer if this is a UAE law document, as my learned friend says. But say it could work, say it could do something. What is it doing? At best, it must be some sort of declaration of trust by BIC over something which it owns. You can only declare a trust over something that you own. So on that assumption, BIC still has legal title. It's the trustee. Now, what it does is it then goes on to say, oh, well, DIFC Investments is your trustee in this respect, but that can't have any effect because you can't declare a trust over something you don't own. So you can declare, BIC are in a position to declare a trust over their rights, but they can't declare a trust over property of DIFC. They can't appoint DIFC a trustee over its own property in favour of some third party. It just doesn't work. It doesn't make any sense. So the best you can construe this as is as BIC saying there's a contractual debt owed to me. I declare a trust over it in favour of the bank. But that doesn't get my learned friend where he needs to go, because then BIC remains that having title to those rights. And so DIFCI can deal with BIC in relation to those rights. And then you've got the point that if it's right that all those particular words declare a trust, that is inconsistent with an assignment of the sort that is understood by DIFC law, of the sort that's features in the cases in the UAE. That is a transfer of title in the interest. And then the next point, as you've pointed out, is what are we given notice of? My own friend says, well, we're given notice of an assignment. So it's not, and we never asked to see that assignment, and therefore we're bound by whatever happens to be in it. Well, not if it's not an assignment, not if it's a declaration of trust. So how, coming back to the central question, how can an agreement between two parties affect the rights and obligations of a third party if it's not an assignment, if it's some sort of declaration of trust? How can that affect me if I don't know about it, if I'm not told about it? And as I say, that there's not a concept of the creation of equitable assignment. So you don't have the situation like you have in England, where, say, for example, two parties agree for the sale of some DIFC land. That gives them some sort of interest in that land. You don't have the English land system in the DIFC, which says there's an equitable interest in that which follows the property if it's subsequently sold, subject to equities darling. You have a system of land registration which creates interest in land. So it's incompatible with that. But more fundamentally, it's not right to suggest that DIFC contract law is modelled on English law. It just isn't. It's well known that it's based on the unidroit principles. And so it has a section which deals with what assignments are. And those are the ones that you've been referred to repeatedly. So it's not a situation where you can say, oh, well, you've been told there's an assignment, so there's an equitable assignment. It's not a situation where you can say, well, you've been told that there's an assignment, so you should be on notice of a declaration of trust, which happens to be in the same document. So there's all these mutually inconsistent assertions being made, but fundamentally, when you look at this assignment, what is you can construe this assignment now. You don't need a trial to do that. And the question is, what is it trying to do? Is it genuinely transferring title? If not, that's the end of the case, as far as I'm concerned. Is there some sort of declaration of trust? Well, that's not sufficient. But even if there is, it's not informed to the DIFCI. All that is said is there's some sort of security arrangement. That's all that is said. An assignment by way of security, yes, but nevertheless security. And then you come to the question of what was consented to. That's page 137, just to remind you. Fundamentally, my learned friend says he doesn't just fixate on the title, acknowledgement, consent, and undertaking. But clearly, that's really what it comes down to. And you can see that is a hangover from the draft that was prepared for signature, which you see at page 134. That's probably all that you can take from it. If it is consenting to, if you do have to answer the question, what is the DIFC acknowledging? What is it consenting to? And what is it undertaking to do? It is acknowledging, consenting, undertaking to do all the things that it sets out in the letter, and this can just simply be construed. Again, you don't need a trial to determine what the effect of that letter is. And it is important, as I say, that the consent that was provided in the draft was deleted. So my learned friend says, is it a counter proposal? I mean, if by that he means, is the DIFC doing something different in this document than it was asked to do in the draft at page 134? The answer is obviously yes, because they've taken a pen to it. And it's not inconsistent with any so-called irrevocable instructions that were provided. There's no irrevocable instruction to make payments in that particular way, even if irrevocable instructions could really genuinely be irrevocable. If the client comes back later and says, well, actually, I told you to pay it all over there, and I said that was irrevocable, but now I want it to go over here. And then I think I made the point on 137, which is that there is just no conflict, because all of the promise and undertaking to do as instructed by the bank is subject to the first words of that paragraph until we receive a contrary instruction from BIC. So the answer to the question, if the bank told me to do DIFC to do one thing, and BIC told DIFC to do something else, who would the DIFC have to comply with? Answer, BIC. That's what it says. That's what it means. And then on Estoppel, I just wanted to remind you, it was rather elided by my learned friend, but the no waiver clause, the point about that clause is not that it prohibits waiver absolutely. It's at page 123 of the same bundle C. We rather skirted over it because I don't think your lordship was able to access it at the time. But I just remind your lordship of the words in the middle, which say no such waiver shall be a waiver of any past or future default, breach or modification of any of the terms or conditions of the contract, unless expressly stipulated in such waiver. That's the point. And those are the sorts of terms which at least in the context of no oral variation terms, we now know are very meaningful. I think, I mean, I don't know whether you're going to be troubled by the UA law position on the question of whether or not contractual prohibitions on assignment are effective. All I'd say is that if you get there, the first case that was relied on rather points in the opposite direction. If you get one in the form of a document that has page numbers, it is probably just worth looking at the bottom half of page 441. So G441 to the bottom to the end of 442. And essentially what had happened was that the debtor had lost at first instance on the issue of whether there'd been an assignment, but then it succeeded on appeal. And there was an issue about the scope of the assignment, whether it covered the particular debt. And then there was also an issue about whether or not the debtor had consented to the assignment. And the Court of Appeal found that the judge hadn't dealt with that defence, and so the judgment was set aside. So it's not a conclusive judgment on the effectiveness of those sorts of clauses, but if anything, it shows that the requirement for consent can be effective. I wasn't going to deal otherwise with those cases because my learned friend hasn't really pressed them. Those were my submissions in reply. Did you have any particular further issues that you wanted me to engage with?
No, I don't think.
Very full.
Amanat means mandate in Indonesian.
Well, thank you. We learned something new. Whether that sheds any light on the case, I'm not sure.
It's a mandate account. That's all it means, presumably. Anyway, there it is. So it doesn't tell you anything very much. I assume that costs will essentially simply follow the event, will they? I'm going to reserve judgment, but are there any complications that people can think of at this stage?
There might need to be some submissions on costs in due course.
Well, I understand that there might need. Oh, I see what you mean. Do you mean on principles as well as on quantum?
It depends on how you decide the issues. So
all right, I'll reserve costs. Right. All right. Okay. Anything else that needs to be dealt with at this stage?
Not from me, my lord. Thank you very much.
Not from me, my lord. Thank you.
Very good. All right. Well, if you'd like just to sign out, then I'll have a quick word with the associate.
Certainly. Thank you.
Thank you, my lord.